Committee, at this point, we will call the meeting to order. It is 10:02. This is the Joint Committee on Special Claims Against the State. The date is November 18th, 2021. We have a quorum. There are 4 of us present. We'll begin by taking attendance, and I'll turn to our staffer. Merle, would you want to do that for us?
Yes, ma'am. I'll go through the attendance. First up, Senator Dietrich.
Present.
I'm sorry, Vice Chair Representative Ralph.
Present.
Senator David Haley, I believe is not present, but he is on his way. Senator Straub is not present, but has indicated she will be attending. Representative Humphreys is not present. She has indicated she will be here. Representative Miller. Representative Miller is here. Representative Samsel. Ma'am, you do have a quorum.
Very good. Thank you so much. For those of you who are here in person, I would just remind you that we have minutes that we will approve after lunch. So if you get the opportunity, please take a moment and read those minutes. Make sure there are no changes that you want to have made on those. And then also, of course, when we're speaking, we want to speak into the mic. And we will have in the afternoon agenda a couple of different things. Besides approving the minutes, we'll have a review of our motor fuel tax refunds. And that's something we haven't done yet this interim. And then we'll have some additional review from some claims that we talked about last meeting. So do you think our first claimant would be ready? 7199 carryover. We said 10:05 and we're just about there. This is Travis Becker, claim number 7199. Mr. Becker? This is Brenda Dietrich, Senator Dietrich. I'm the chair of the Joint Committee of Special Claims in the state legislature. The committee is hearing your claim for $515, and you are on speakerphone with the committee. So the committee's been...
Yeah, I can hardly hear you guys.
You can hardly hear us.
Yeah.
Can you hear me any better now?
No, she's got it up full blast, too.
These are all...
I really didn't hear anything you guys said so far.
Okay, we were pausing for a minute to see if we can increase the volume. Can you hear me any better now?
No, it's real echoey.
Do you want to bring that up here, maybe? Or the speaker part, that part. Let's see. Mr. Becker, we're moving things around. Is this any better?
Just a little bit, yeah.
Okay, very good. We'll try this. So we've been given all the documentation for your claim to review, including your description of the loss. I'm going to give you the chance to tell the committee anything else you want us to know about that claim. When you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of the issue. And then when that's completed, the committee's going to take some time to determine the disposition of your claim, and a written decision is going to be provided to you within 21 days following the date of that decision. Do you understand?
Okay.
Are you good?
I do.
Okay, very good.
Yeah, I'm here.
Would you like to tell us now a little bit more about your claim?
So essentially, I got attacked in September 13th of 2020, and I did some OSR time, and then I went back to population for like 10 days. And then I got OSR'd again for the original incident. And then when they took me to RHU, they waited a while to pack my stuff out, and all my stuff got stolen. on my cellies essentially. And for the property to come in and it got denied, so then I sent the stuff over to you guys. Just been waiting on that to come through. See what you guys decide.
Thank you.
I didn't get any trouble. I just got sent out for security reasons. It's the RHU unit.
Thank you. Thank you, Mr. Becker. Committee, do you have any questions of our claimant?
No, I don't think so.
Thank you. I think we'll hear from the attorney now. Libby, would you like to provide information from the department?
Thank you. Mr. Becker's requested $515 for property loss. He says that he was placed in protective custody in January of 21, contrary to his wishes, and his television, radio, Adidas shoes, and some food and hygiene items were stolen. He said that CO Stewart stated that his property had not been packed for 3 to 4 hours, and that this delay is what resulted in the loss of his property. And he also alleges that staff failed to review security footage. On January 22 of 2021, Mr. Becker filed a facility claim for $445. The facility claim response indicated that Mr. Becker's allegation about the C1 officer saying that the property had not been packed for 3 or 4 hours could not be verified. It went on to note that the only items noted as missing were a television and radio, but there was a radio listed on the inventory.
You had 2 of them.
Additionally, several of the food and hygiene items were listed on the inventory. And when Mr. Becker signed the inventories for receipt of his property, he did not note any missing Adidas shoes. His present claim is for $70 more than the facility claim, though it is for the same items. His property was inventoried on January 19th. That inventory includes 6 pages accounting for 107 items, plus the electronics checklist. It includes many food and hygiene items and no Adidas shoes, and Mr. Becker signed it on January 21st without noting any discrepancies regarding these items. The electronics checklist includes a notation that a 15-inch television with remote and a radio were missing, but there is a radio listed on the checklist. IMPP 12120 permits inmates to possess only one radio. IMPP 12120 provides that inmates are responsible for noting discrepancies when signing property inventory forms. The only items that he noted missing were a television and a radio was accounted for. Facility staff responding to the present claim also indicated that with knowledge of his impending move, it is likely or at least possible that the property was traded, consumed, lost, or stolen prior to being packed out by staff. Based on this information, we're recommending that the claim be denied. I did get a call. I would note we reached out to the officer. I asked the question, when the facility response says that it could not be verified, does that mean that it was denied, or does that mean we couldn't ask the officer? So I had facility staff reach out to that officer who said he had no recollection of having that conversation. He doesn't usually have conversations with the D1 cell house staff, and that's not a comment that he would likely make to an inmate.
Thank you, Libby. Does anyone have any questions of our attorney for the Department of Corrections? All right. Mr. Becker, is there anything more you want to tell us? You were starting to speak during our attorney's testimony.
I just don't understand why they didn't never review the footage, because every 5-man tank in D1 has a camera right in front of it. If they would have reviewed the footage, they would have seen that the stuff got taken because they didn't go pack it out in a timely manner. So basically, I got over $500 worth of stuff stolen from me.
Okay, thank you.
So, and then on the radio part of it, I had 2. I just hadn't sent one out, and they took one of them, and I still had one.
Very good. Libby, did you have anything you wanted to add to that?
No, thank you.
Committee? Any other thoughts or questions? Very good. Thank you, Mr. Becker. We're going to move on to our next claim. We'll let you know in the next 21 days what we find. Okay?
Okay.
Thank you.
Thank you.
I would also note that we now have Representative Humphreys and Senator Straub here with us. So we will move on now to claim number 7193. You will note there was some additional information provided by this claimant from our last meeting.
County Correctional Facility, Unit Team Counselor Smith speaking.
Good morning. This is the Joint Committee on Special Claims Against the State. We are looking for Mr. Thomas Everson, please.
Yes, he's sitting right next to me.
Thank you.
Hold on.
Mr. Everson?
Hello?
Hi, this is Senator Dietrich. I'm Chair of the Joint Committee on Special Claims in the State Legislature. The committee is hearing your claim for $124.25. And you have provided us some additional information, which we'll look at in just a minute. So you are on speakerphone with the committee. We've been given your documentation, including the additional information. When you're done, I'm going to ask you to share with us what more you wanted us to know about your claim. And then when you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of the issue. When that's completed, the committee's going to take some time to consider your claim, and then we will give you a written decision within 21 days following the date of that decision. Do you understand?
Yes.
Very good. Would you like to share with us what more information you have provided?
Okay. Unfortunately, at the time I've changed cell houses since then, so I'm with a different unit team. Unfortunately, the unit team I was with didn't want to assist me in getting some of the paperwork. However, with that being said, she said that your committee could obtain any information that you needed. A lot of the stuff that I had lost, not all of it, but some of it, I received in property claims, and I put the Form 9s and stuff where I tried to get the information, and she didn't want me to have it. She said I should already had it, but I still sent to I want to say receiving and discharge A&D here, and as well as I tried to ask her. I think it's in Form 9s in there, maybe responses from Petty John, the person that was my unit team that did the actual property claims. He said on his thing that he didn't have itemized list of the things that he'd given me, but there is a form that I signed stating the value, the dollar amount, and if he were called, he would also let them know. A lot of times I don't know where he get it from, lost property or whatever, but in his office when he was settling property claims, he would have TVs, fans, hot pots, shoes, clothes, just a variety of things, and you could pick what it is you wanted up to however much it was that you owed. So the Red Wing boots that I had, I didn't personally buy them through the canteen, but I received them through a property claim. And those were the papers I was trying to get my unit team to get, but she wouldn't get those. And he said that they were supposed to be in A&D. I sent a Form 9 to A&D, and they said they didn't have the paperwork, but I definitely signed the paper for the property that I received. There's a unit team sitting here now. I'm not for sure if he's aware of how that procedure is or not, but it's the same, I'm sure, everywhere. As a matter of fact, he's looking at some of them right now that they wouldn't even give me. But they are definitely there where I signed, where he gave me property to compensate for the stuff that had been lost. And again, I'm looking at them right here, but it's the paperwork she wouldn't give me so I could submit to the authorities. And he's got them all on his computer right here.
Thank you, Mr. Everson. Committee, do you have any questions of Mr. Everson before we hear from the Department of Corrections? All right. Libby, would you like to give us any additional information?
Thank you. Just addressing what's developed since the last hearing. A couple of days after the last hearing, I got an email from the facility saying we've located his Red Wing boots. But then Tuesday, I learned that he had submitted some additional information. His additional information pretty much says, I'm having a hard time getting help getting the additional information. So I started reaching out to staff about what's going on. Yesterday, I got a few responses, started kind of breaking it down, what I can see. I do see a purchase of a hot pot in 2017, some shorts in 2020, some thermals in, well, those were in 2014. So at quick glance, sort of mostly confirms what the facility response said, which is that there's not much record of purchase of most of the items that he's claimed. But to give a thorough response, I would need more time to break down what I've found in the purchase history and what he's saying and all of the, any property that's been given to him as a compensation or for some other loss, which is what he's saying, some of what he's trying to acquire. So we would stand by, I think, the original responses, but if you want me to analyze what he has submitted, I would be happy to do that if we can carry it over to the next hearing.
Thank you. Questions? Representative Ralph?
Thank you, Madam Chair. Hey, Libby, a couple of things. Early in your response, you made the reference, did they find boots?
They found Red Wing boots, but when I started looking at the purchase history, he purchased some on July 8th of this year and on June 14th of this year, both of which would have been after this alleged loss.
So whose Red Wing boots did they find?
They may have been his, that he was given for something else. It could be that as I go deeper into the purchase history, I'll find that he purchased some years ago. It's not really clear why he would buy boots in June and July of the same year. So there's some things I need to kind of sort through.
Okay, I think we probably need to sort through this, but just one other item just on the edge of this, and I really appreciate the stresses that the department is under right now and the staffing and all those pieces, and this becomes an extra on top of all of those pieces. I would really prefer, though, not to hear that the staff is saying to someone that we can go find our own stuff when we've made a request for it. So if, in some nice way, if you might pass along that that's probably not the response that we would normally want to hear in those instances, that would be appreciated. But I'm kind of wondering at this point, if at least with the boots, I'm leaning toward not understanding why the boots don't get back to him. So some additional inquiry is probably warranted.
And that's my feeling as well.
Any other thoughts or questions? Representative Miller?
Thank you, Madam Chair, and I'm sorry I'm so slow. Back to the boots. You said you found some Red Wing boots.
Yes.
What happened with those? Were they returned to him? Were they given to him? Are you just hanging on to them? Or
That I don't know. I assumed that they had been given back, but I realize that's probably not a safe assumption at this point. But they wouldn't have been.
Stop right there.
Okay.
'Cause maybe he can clear that up.
Very good.
Mr. Everson,
Yes.
are you in possession of those Red Wing boots?
No, they won't give them to me. That's why I tried to order twice some more boots so I could have some shoes. And both times I tried to order them, the company either didn't have them or was some problem. Thus why I didn't get them either time I ordered them this past year.
Thank you, Mr. Everson. So committee, are we in agreement that we probably need a little bit more time to sort through this for Mr. Everson to be fair? Representative Ralph?
Probably at a minimum, because I'm really having difficulty, the same as the center of, if they're, those boots sound like they ought to be back with Mr. Everson.
Representative Humphreys?
So my question is, we can get more information, or can we see that his boots are given back to him? Is that an option?
I will ask the attorney. Is that an option?
Unless there's some reason, some actual policy reason or some reason that they have not been given to him that may have to do with he already has another pair in his possession and he can't have two, or I don't know what the reason might be that they've held them. But if there's no good reason for holding them, then yes, they should.
Because as Representative Ralph mentioned, we know there's a stress on personnel and things, and this just seems like we can give them the boots back, and then you don't have to go back through years of purchase history. And I mean, if you want to, if that's what you feel like you need to do, of course, you should do that, but.
Only to the extent that the claim involves other property as well. He's claimed other items.
Yes, and maybe that does need more information. I would be in favor of seeing if he can get his boots back.
I think that would probably be our easiest and best solution. We don't know what the unintended consequences of that might be, or if there are other issues involved. But do you think at this point in time, you could maybe just do a little research on this, not to go too deep into these weeds? And if he can get his shoes back, I think we would be very comfortable with that.
Okay.
Correct, committee?
Okay.
All right, so we're not going to take action on this at this point in time. We'll wait until our meeting next month in December, and hopefully we'll have resolution for this. Is that possible, do you think, Libby?
To have it resolved by December?
Mhm.
I should think
16th.
so.
Okay, very good. Thank you. Thank you, Mr. Everson. We're going to do our best to help you here.
All right, thank you.
Thank you. Now, we have another item from Mr. Everson, and this is claim number 7195. And this is for $1,354.63. Are you still there, Mr. Everson?
Yes.
So I'm not going to go through my remarks because we've already talked to you. You know what we're going to do. We're going to let you tell us about the claim, and then we're going to let the Department of Corrections give us more information on the claim, and then we'll ask questions of you. So would you like to share your thoughts on claim number 7195?
Yes. The reason why it was so high, first of all, is because my player, MP3 player with all my music was involved. Your records show since that time, even though I've never recovered my MP3, I've since then bought the Score 5, a new player that has all my music and stuff on there now that I had on my other player. So in regards to that, I think the only thing that would need to be really reimbursed on that would be the MP3. I have no idea where it's at. The stuff, the rest of the stuff is primarily just basic canteen stuff that I go to the store and buy every week. When they shook my cell down, we are allowed to buy locks for our lockers, and the whole purpose of having a lock is to secure your property. Unfortunately, when they come in and shake down, they open up your lock, and then they leave your lockers open. And it's anybody that comes in, or not, or when they open the doors for chow, anybody can come in your cell because it's impossible for one officer to stand at the front of the walk and watch everybody that's coming down the walk when you have so many people coming. But again, the records will show that I purchased locks. I put the locks on my locker. When they shake down, instead of shaking my area down, and then when they get done putting my lock back on there, they leave everything open. So the stuff that comes up missing is not based on my negligence. It's just the fact that they're not doing what they're supposed to do when they get done. So it leaves all my property vulnerable for anybody that decides they want to take some. I've had this problem in the past. I've talked to the unit teams about, when they come in and shake down. Obviously, we don't have no say-so when that happens. But again, the whole purpose of purchasing locks from the canteen is to secure our property. So why do I need a lock if you're going to open it up and then leave it there available for anybody and everybody to come through? So that's how I end up losing all my stuff.
Thank you, Mr. Everson. Does anyone have any questions of Mr. Everson at this point in time? We'll next hear from the Department of Corrections Attorney. Libby, would you like to share the department's position?
Yes, thank you. I think the department would stand on its original response. And again, combined with comments that I've made today, the same response applies as in terms of researching the purchase history for some of these items. Some of the items that he's claimed, I again would note that many of those were seized, confiscated because they were altered or because they didn't, they were facility property, that sort of thing. And again, not everything that he's claiming now was claimed originally. And I would ask if he could give me some idea of when he purchased, when and where and how he purchased the MP3 player, how he acquired that. That would help me locate that in the purchase history.
Mr. Everson, did you hear that request? We have no receipt
Yes.
for your purchases. Yes.
I purchased that here at Hutchinson Correctional Facility, if I'm not mistaken, 2009, 2010, when they first started selling those players to us. It has to be on my record because I bought it here. I've been incarcerated since 1980. I've never been released. So everything I purchase is come through the canteen or a fundraiser or whatever means they allow us. And my unit team is looking it up even as we speak. But yeah, I bought it here.
Very good. Thank you. Did that answer your question?
Yes.
Any questions, committee? Yes, Representative Humphries?
Thank you, Madam Chair. So in these claims, just so I understand a little bit, is there and is the department's position ever, yes, partial, we can refund this or fine this or do this, or is it kind of all or nothing in our committee? How do we handle that?
If we will do a partial payment if we can find, if there's things that we can identify that should be paid that I can show a purchase history for and can't explain where they went, that it was lost in our possession, then sure, we would recommend payment for.
And when the records show when there's an inventory, and let's just say he did have an MP3 player, and then it's gone, why do you have to go back and find the purchase record if there was one in the inventory? We know that he had one.
Because it may have been in his possession, but not rightly so. It may be something that was among his property when his property was packed, but he never bought it, and so he shouldn't have it. So it's contraband in his possession, and he wouldn't be entitled to that. He certainly wouldn't be entitled to compensation for it if it was never properly acquired by him.
And that would mean bought, because there's no gifts.
I was going to say if it wasn't purchased by him, but there is also property settlements. I think he was referring to that earlier, that if we've lost something, sometimes we settle a claim with an inmate by saying, we lost your hot pot, but we can give you another one. I don't have a hot pot to give you, I can give you a radio. There are some things like that. So it could be that he didn't purchase it, but it was given to him. And I don't know that that would be so with an MP3 player, but sometimes they will have property that they didn't have purchased, but was properly given to them. But there would be a record of that in the property file.
And there's no exchange of property between inmates.
Correct. That's against the rules.
Thank you. Thank you, Madam Chair.
I might add, and that is, I think, why we spend so much time on, do you have receipts?
Yes.
Is it on your inventory? Was it properly acquired? Because there are so many situations that you have to deal with in these facilities. So,
Correct.
committee, do you have any other thoughts about this claim? Very good. Thank you, Mr. Everson. We'll get back to you within 21 days.
Excuse me, can I say one thing?
Sure, go ahead.
My unit team just found it on his computer, June the 3rd of 2011. No, that's my new one. No, that's MP3. Yeah, okay. Yeah, it's June the 3rd of 2011. It cost me $75.73.
And was
It's
that,
on his computer screen. Yeah, that's him.
Mr. Everson, was that your MP3 player?
Yes, that's when I first bought it. I'm looking at it on his screen right now. What is that?
$5.73.
That's how much it cost. And it was purchased on 6/3 of 2011
Thank you.
at Hutchinson Correctional Facility. It's on his computer. I'm looking at it right now.
Thank you. Representative Humphries, question?
Just a quick question. Thank you, Madam Chair. If I'm not mistaken, when a resident has an MP3 player, they can purchase songs to go on it. And so you have records of all of the purchases for each inmate, what they put on their own MP3 player? Because I would think some of his claim is about not just the 75, 73, but also all the music that was on it.
Yes, part of his claim, I think, is like 990. It's in my letter, I think.
Yeah,
900.
through the years, he's added
Yeah,
music.
about
or
$900
whatever.
of his claim is for songs, which do remain available to him to use on another player. And I think he said that he does now have that on his new player.
Okay. All right.
So-
Thank you. Thank you.
Thank you very much. Anything else involving this claim? Thank you, Mr. Everson. Appreciate it.
Right. All righty. Thank you.
Bye-bye. Okay, well, we're pretty much on schedule. The next claimant is claim number 7208, Kilby Lit.
Good morning. This is you, Team Seymour.
Good morning. This is the Joint Committee on Special Claims Against the State. I'm calling for Philby Lit, please.
Yes, ma'am. He's sitting right across from me.
Thank you.
Mr. Litt?
Yes.
Hi, this is Senator Dietrich. I'm chair of the Special Claims Committee in the state legislature. The committee's hearing your claim for personal property loss of $277.95. So you are on speakerphone with us. So we've got all the documents that you provided about your claim. We're going to hear anything more that you would want to tell us about your claim, and then we're going to hear from the Department of Corrections attorney about the department's position. And when that's completed, the committee will take some time to consider your claim, and a decision will be given back to you in about 21 days. Do you understand?
Yes, ma'am.
Very good. So we have your claim information in front of us. Is there something more you'd like to tell us about the claim?
Yeah, okay. So when I submitted the claim, I was still in segregation and didn't have some of these items, as Houston Seymour mentioned when he recommended it to be denied on July 20th. Since then, he had mentioned that some of those items were in the segregation non-allowables and storage. The items that ended up being in my segregation non-allowables was my Weston clamp-on lamp, the Mighty Bright book light, the combo lock, both of the surge protectors, the 2-foot and the 9-foot one, but not the 6-foot extension one. And so the items that were still not there were the Skull Candy headphones, the Mint and Speed Stick deodorant, the 3-plug 6-foot extension, the Clear Tunes radio, the gel insoles and Nike Revolution 5 shoes from the clinic, as well as the shoes. So the other items ended up being in my segregation non-allowables, as was stated
Very good.
by Unity Seymour.
Thank you. Thank you, Mr. Litt. Does anybody on the committee have any questions of Mr. Litt? And we'll next hear from the Department of Corrections Attorney. Libby, would you like to address us?
Thank you. Mr. Litt's facility claim was for $277.95. He stated that he was moved to central unit on May 20th, and the claimed items were not in his property or on the inventory or on the shakedown reports. The facility claim investigator spoke with Sergeant Nichols, who packed Mr. Litt's property. Sergeant Nichols fully recalled packing Mr. Litt's property because of the large number of excess items that he had, and he did not recall seeing a radio. Mr. Litt had 2 boxes of property in storage at that time, which contained the padlock, headphones, lamps, surge protectors, and food and hygiene items. The facility response noted that Mr. Litt had recently sent out 3 pairs of running shoes, including a pair of Nikes. In his present claim, which is for the same amount as the facility claim, Mr. Litt argues that he should be compensated at least for the items not confirmed to be in storage. He characterizes Sergeant Nichols' comments as an admission of negligence regarding the radio. Facility staff responding to his present claim stated that he was moved on May 20th and his property was inventoried, including 2 pages of excess property listed on a shakedown and search report. On May 26th, his stored property was inventoried. He remained in segregation until July 1st, when he was moved to the clinic, and on July 2nd, he was released back to segregation, and his property was again inventoried. The inventory from May 20th includes a padlock and headphones, and it does not include any of the other claimed items. On May 25th, Mr. Litt signed all pages of that inventory without noting discrepancies. There's no record of staff ever having possession of the claimed shoes, insoles, radio, surge protector, or power strip. The May 26th inventory of his stored property does include a lamp and a reading lamp, 2 combination locks, 1 earplug headphones in the case. The July 2 inventory includes deodorant, 2 headphones, earbuds. None of the other items are listed on the inventory, and again, he signed for receipt without noting any discrepancies. Mr. Litt purchased a pair of Nike shoes on March 11th for $86.87, and then he had a pair removed from the facility on May 14th. On March 12th of 2021, he received 5 gel insoles as medical equipment purchased by Centurion. the medical provider. Mr. Litt was in possession of an excessive amount of property. Much of it was listed to be removed from the facility, and the rest was inventoried. On 2 occasions subsequent to the move, Mr. Litt signed property inventories indicating that he had received the listed items without noting anything missing. It appears that he received many of the claimed items, and there's no showing that some of the claimed items were in his possession when his property was packed, or that staff ever had possession of them. And for those reasons, we're recommending that his claim be denied.
Thank you. Committee, do you have any questions of the Department of Corrections Attorney? Representative Ralph?
I think, Libby, just more as a general information, there was some spot in there in the report that talked about that the claimant had sent out shoes. Do you know what they're talking about when they say they were sent out?
Sent out of the facility, sent to home or wherever. So.
Great, perfect, thank you.
Anyone else with any questions on the committee? Mr. Litt, is there anything more you want to add?
There's just a couple things. As I stated when I sent the forms to you guys, the shoes specifically were sent out because I have multiple pairs. As I said, as Master Sergeant Hancock and Master Sergeant Duso will be able to attest to. Also, I cannot sign and note discrepancies on said non-allowable property because they do not give it to us. They just send it down to the misses and discharge. And that doesn't actually, that was never in my presence until a couple of weeks ago when I was out of segregation. And those items, again, were not listed on those inventories that are attached. Those are the original inventories from that property, both from May 20th and July 1st. Those items were still not on those inventories. And so I already property claimed them. So, I already done the property claim on them, so I can't denote a discrepancy on that if I'd already had the property claim in, was my understanding from the Master Sergeant down in A&D.
Okay, thank you. Thank you. Committee, any other questions? Thank you, Mr. Litt. We appreciate you being on the phone with us today. We'll get back to you with our decision within 21 days.
All right, thank you, ma'am.
Thank you. The next claimant is number 7194. And this is a request to withdraw the claim. So we actually do not need to hear that. We may want to enter this into the record. Merle, you had some thoughts on that?
Madam Chair, if I could, I would just, the claimant has submitted a signed document indicating that they would like to withdraw their claim, and I can just read through that very quickly. It's one sentence, just so it's in the record. Mr. Hayward says, I, Stephen Hayward, do hereby withdraw my legislative claim 7194. I am choosing to withdraw my claim because I have received an RCA radio in settlement of my claim, and that is signed the 17th of November, 2021.
Thank you. At this point, we do have a few minutes before we need to hear our next claim. Would you want to take action on the ones that we've heard so far this morning? We'll start with claim number 7199 for $515. Do I have a motion? Or do you want to think about it?
I apologize, I've forgotten what the gist of that claim was, because all I wrote down was claim of timeliness.
That was Mr. Becker. I have to go back and scroll through that myself to remember exactly what he was.
Madam Chair, it might be easier. Libby, can you remind us what that's?
Would you, Libby, please?
It was property loss that included a television, radio, Adidas shoes, and hygiene. He had signed the inventories. The only thing he noted missing were a television and a radio, and there was a radio on the inventory. And he's only allowed to possess one by policy.
And this was about they packed him out in this one?
Yeah, he said that there was a 3 or 4 hour delay in packing the property.
That's
staff
the
has said-
timeliness claim, that they didn't get him packed out quick enough. Move to deny claim number, Madam Chair, move to deny claim number 7199.
Do I have a second? Representative Samsel? Questions? Yes. Representative Humphreys?
I'm going to vote that I would like to approve this claim, actually, for the reason being, I think you said he had I thought you said 107 items, and I understand hygiene items you can forget. Okay, but a TV, like that's pretty clear, and the radio, that makes perfect sense. He's only supposed to have one, no issues there. The TV, I'm troubled by that it is gone. So I just would like the committee to know that I won't vote yes to disapprove the claim.
Thank you.
Mm-hmm.
Any other thoughts?
Sort that out.
Madam,
You won't vote yes to disapprove.
I mean, that's what I said, because right now the motion on the
Triple
table.
negative, and I have trouble keeping up with two. So
Vic, come on. Okay, there's a motion on the table to disapprove the claim, and I just want the committee to understand that I will not be voting yes on that motion.
And I
We'll vote no.
I have been convinced by your persuasive arguments and will be joining you in not voting to whatever you want.
Thank you. Thank you, Madam Chair.
Representative Ralph.
let me, one more question then, because I understand the representative's concern, and I think we've talked about some of this concern with several claims in that regard. On this one, remind me was there some specific reference or concern about the TV in terms of your response?
There was no TV listed on the inventory. There's no showing that it was among his property when staff went in there to pack the property. I mean, he could have disposed of his TV before we ever got there to pack the property. We don't know.
Okay, and Madam Chair, and in deference to the representative, I think this kind of points out some of our ongoing concerns with all of these claims. Is I really don't want to hang claim. That's a bad way to put that. I really don't want to approve claims against the department in terms of just because an inmate said they had some piece of property and we don't have any way of ever showing that the piece of property was there, while also acknowledging that because of the volume of things that are going on and the impact it has on staff, that there will certainly be occasions where we miss things, where the department will miss things that should be attributed to us. And so I really do struggle in these instances with how we put that on the department, because if something wasn't there, unless there is some negligent conduct on the part of the department, I certainly don't want to approve claims against them for those instances. And I will acknowledge that we will, from time to time, make inconsistent determinations about when we pay for things and when we don't. And I think that is a struggle for us. I would like for the department to know that we understand it's a struggle for them as well in those instances. And when we approve claims or don't, I certainly hope that the department doesn't take that as some overarching comment on how they're conducting their business. That's more the words than I intended to say at that point.
Representative Ralph, I think you put into your oratory exactly what many of us are thinking, and this is difficult. We're not there. We're not in the facilities. We have to just use what we have in front of us, so I appreciate that. So are there any other items for discussion on this motion? All right, we have a move to deny. We have a second. All those in favor of denying the claim signify by saying aye. Aye. All those opposed? No. So it's 3-3. Haley, so the motion fails. Or?
Might I ask in this instance, I don't remember under our rules, is the chair required to vote?
Am I required to vote?
It sticks in my head that you're not. But I don't.
Madam Chair, I can, let me look real
Still
quickly.
fail because it's 3-2.
Oh, okay.
Motion would still fail one way or the other.
Thank you.
All right, motion fails. Yes. Representative Straub.
Madam
Senator
Chair.
Straub, I am so sorry.
That's okay.
Sorry.
Would it be possible for the committee to approve a portion of this claim? I'm not necessarily in favor of denying all of it, but a portion of it. I believe Libby had stated that the radio is back in his possession. Could we subtract like that item off of the $515 and approve the television and the personal hygiene items?
We certainly can. Do you have a number there, Libby, without me?
I don't know if you
Scroll
itemized the,
through this. The TV with remote was $265. The radio was $30. The food and hygiene was $120 to $150, and the shoes were $71.67. So,
Well,
Representative Miller?
I'm not excited about the shoes, given that that was actually seemed like an afterthought. Whatever those other items added up to.
$265 for the TV with remote. Let's say $120 of food and hygiene. That's $385.
I see the list you're looking at, ma'am, so I can do some quick math, and basically, we're looking to exclude the radio, if that's,
Shoes.
and the shoes, okay.
I have $385 because I took 120 of the food and hygiene.
Yep, that's correct, ma'am. Amount of
Ralph? Thank you.
items,
Oh.
excluding the items you've talked about, the value would be 385.
Representative Ralph?
Libby, when we approve these claims, how's that done with the inmate? Do we frequently approve just a dollar amount and they get that back in credit on their commissary, or do we actually replace items like with something like this?
if it's a committee recommendation to pay, that goes to the legislature and becomes part of the appropriation bill, and that goes to the inmate account, where there may be offsets and things for restitution or whatever things they may owe, whatever debts they may owe. So it would be next spring or summer before they would see that money on their account.
But we're doing dollars and cents as opposed to
Yes.
replace a TV.
Yes, unless, I mean, there have been times when we've been able to agree that I'll go and see what I can do about negotiating a settlement with.
That's the piece that
Property.
you try to take care of, or potentially try to take care of.
Try to. In this case, this is not one where I saw negligence that I thought maybe we do need to settle it. So that's not something I've explored.
Sure.
Maybe it's a possibility. I don't.
Okay, thank you.
So the motion would be, if the committee is so inclined, to approve a claim of $385, claim number 7199. You'd be costing out the TV and the food and hygiene items. If you so want to go that direction, I take a motion.
Madam Chair, as I kind of mentioned before, the food and hygiene, I can see how those are iffy and, 100 and something items. So I would be inclined to move that we reimburse for the TV only.
Second.
$65. Okay, motion and a second. All those in favor of approving a claim of $265, which is the cost of the TV with remote, for claim number 7199, please signify by saying aye.
Aye.
Anybody opposed? Right, we will approve that. Thank you. Great discussion, good solution. On claim number 7193, we talked about not taking any action yet because we want to find out more about these Red Wing shoes. Did he receive them or not? So we are just, what would you want for the minutes, Merle?
Ma'am, it would be best if if you want to wait to consider this, if we actually have a motion to carry over.
Thank you.
The
Okay, Representative Ralph moves we carry over. Do we have a second? Representative Humphreys. All those in favor, say aye. Any opposed? Okay, we will carry over claim number 7193 specifically because we're looking for information about the shoes. Claim number 7195, this is Mr. Everson for $1,354.63. Committee?
Move,
Representative Ralph.
yes, Madam Chair, move to deny specifically claim number 7195.
Is there a second? Representative Samsel? All those is there any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, motion passes. Claim number 7195 is denied. Claim number 7208 for $277.95. This is a Libby, could you remind us, claim number 7208?
Let's see. He was moved from the east unit to the central at Hutchinson, says his property, some of his property wasn't packed. It's Nike shoes, gel insoles, clamp-on lamp, book light. He does say that he has since acquired many of those things now that he's been out of seg and gotten the property that was not allowed in segregation, which he was told in response to his facility claim was in boxes waiting for him to get out of segregation. He says some items are still missing, but we point out that he did sign inventories on several occasions. The gel insoles were purchased by the medical provider, not by him. And there's just no evidence that some of these items, anything that's not listed on the inventories, there's no evidence that it was in his possession when we packed the property.
Thank you. All right, do I have a motion for claim number 7208? Representative Ralph?
Motion to deny this claim, 7208.
Second. Representative Samsel. Any discussion on this claim? All those in favor, please signify by saying aye. Any opposed? Okay, motion to deny is passed, claim number 7208. And then we'll want a motion to withdraw, or that we have accepted the notice to withdraw claim number 7194. Is there a motion?
So moved.
Representative Ralph, is there a second? Senator Straub, all those is there any discussion on that? All those in favor signify by saying aye.
Aye.
Any opposed? Okay. We approve the motion to withdraw the claim. All right, we're just about on running a few minutes late. We have claim number 7163, and if you recall, we wanted some additional information on this claim. This was Mr. Todd. And we did not receive any additional information, no receipts, nothing. So we'll get him on the phone.
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2 and listen to the prompt. For visitation, please dial the extension number. Press the star key to start over. We will now connect you.
You have dialed is not in service. If you feel
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2 and listen to.
Please dial the extension number. Press the star key to start over. We will now connect you.
Okay, we're going to try the first number again, and if that doesn't connect, maybe we'll move on to the next claim and come back to that. Okay, very good.
Thank you for calling the El Dorado Correctional Facility. If you know your party's
Please dial the extension number. Press the star key to start over. We will now connect you.
Hi, this is Unity Buchanan, El Dorado Correctional Facility. I got Mr. Todd in my office here.
Yes, ma'am, we were trying to reach you for Mr. Allen Todd.
Correct. I just now have him in my office. We had to do the escort. We're short-staffed.
Thank you.
Mr. Todd, are you there?
Yes, ma'am.
Hi, Mr. Todd. This is Senator Dietrich, Chair of the Special Claims Against the State Committee in the Legislature. We had carried over your claim because we had asked for some additional information, perhaps a receipt for your gold chain and crucifix that you had put on your claim against the state. Were you able to locate that additional information?
Nah, I talked to my sister and she didn't feel comfortable giving up her credit card receipt.
Okay, very good. Thank you for that, Mr. Todd. We appreciate that. Committee, do you have any questions or thoughts on this? Okay, thank you, Mr. Todd. We will get back to you with our determination here within 21 days. Thank you.
All right, I appreciate y'all.
Thank you. Have a good day. We will move on to claim number 7204.
Ma'am, did you want to hear any
Oh, I'm
from the
sorry.
agency on
Libby, did you want to chime in on anything?
We
Okay.
stand on the-
You had a recommendation, and I think we probably will just move with that, if that's okay.
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension,
Please dial the extension number. Press the star key to start over. We will now connect you.
hello.
Yes, good morning. This is the Joint Committee on Special Claims Against the State. We're looking for Mr. Jay Heidi, please.
Yes, this is him.
Mr. Heidi?
Yes.
Hi, this is Senator Dietrich. I'm Chair of the Joint Committee on Special Claims Against the State. The committee is hearing your claim for personal injury for $25,000 today, and you're on speakerphone with the committee. We can hear you, and we'll give you an opportunity to talk to us in just a minute. So we've been given all the documentation for your claim and the description of what happened. So we'll ask you to tell us anything more you'd like us to know about that claim in just a minute. We also have the attorney for the Department of Corrections here who will also provide the department's side of this issue. And when that's completed, the committee's going to take some time to consider your claim, and then our written decision will be given to you within 21 days. Do you understand?
Yes.
Very good. You now have the opportunity to talk to us about your claim. What would you like us to know?
My question was, did you have the facts of what happened on the allegations that I put forth?
I believe so. We have everything that you've provided with the timeline, events, your handwritten notes. Is that what you're talking about?
And yeah, and the medical reports and the incident reports and the DR from the person that did the battery to me.
I believe so. We've got medical records. I believe so. Merle, do you believe we have everything he's asked for here?
Ma'am, you have everything that he submitted with his claims. If
Okay.
there's additional material that was not submitted with his claim, then that would not be in the packet. It does sound like the majority of the items he's referenced are there.
We've got a pretty substantial amount of information here. Would you just like to put in your own words to us what happened and why you're filing this claim?
Sure. I'll briefly say what happened, and then I have something written.
All right.
I may withhold something. I'm not sure, but I'll say on around June or July 2016, inmate Bartley struck me with a large piece of concrete and battered me and continued to hit me, and there was no help that arrived. And then I finally was taken to the clinic, and then I was hospital bound in the clinic at the Lansing, and I was there for quite a while in admin seg, and then they kicked me over to the hole and admit another segregation unit in a nasty environment. And I never received any type of restitution or any type of anything from that. And I tried to file a property claim about it, or an injury claim, and they wouldn't take it because they said I needed to suck it up, and they threw it away, is what unit team did. And that was unit team Escobar. So I tried to file and go through the administration remedies and stuff. And this is my last resort. And then on about 2019, I was in El Dorado, and inmate Hooper headbutted me when I was handcuffed to the table. And he was escorted by 3 guards. And it seemed kind of unfair that 3 guards couldn't contain him, and I was just defenseless. And it seems like it's been a ongoing issue, like a continuous harm doctrine, I'd put it that way. And then on before that, on probably 2018, guards in Lansing came to the mental health area when I was in Lansing and sprayed me, and there was no reason to spray me. And they handcuffed me and then slammed me into the ground for about 30 seconds. It was on video, and I have witnesses. There was witnesses there, and it continued for like 30 seconds. They just kept slamming me in the ground, and I wasn't resisting or nothing, and I was handcuffed and maced, and I was defenseless, and it seemed very unfair, and I was upset about that, and I've filed about that. So that's basically everything I filed on and why.
Thank you, Mr. Heidi. I have a question for you. Have you hired an attorney, and are you going through the legal system with any of these claims?
Who?
Do you have an attorney who is working with you? And are there any legal claims that have been filed?
Not that I know of. I filed on my court case on a 60-1507, but it's about to be dismissed.
Did you say you do have a
And
court case? I didn't understand that. Did you say you do have a court case?
not anything particular to this case. No,
What do you
not
have,
that I know of.
what do you have a court case on?
My criminal case.
Okay, thank you. I understand.
Yes.
Very good. Committee, do you have any questions for Mr. Heidi? All right, Libby will let you then explain the department's position.
Thank you. Mr. Heidi's written claim appears to be based on 3 alleged incidents occurring between 2016 and 2019 or 20. He says he was attacked by an inmate at Lansing in 2016, injured by staff at Lansing in 2019, and attacked by an inmate being escorted at El Dorado in 2019 or 20. He asserts that this is continuous harm, and he requests $25,000 or release to electronic monitoring or a jail program, a license to use medical marijuana, the right to carry a firearm, and to be permitted to move to Colorado. On June 30th, 2021, he filed a facility claim against Lansing. He cited a date of loss of around 2015 or 16, 2018. He stated that another inmate had struck him with a brick and staff was negligent, quote, at letting him out of SEG due to his lies and manipulations, end quote. He added, also, clinic guards attacked me in cuffs 2018. The claim was denied because it was filed outside of the 10-day limit for personal injury claims that's set forth in policy. In his present claim, he makes several references to pursuing these issues in court. He says that he wants to avoid appeals court, and he includes a letter dated June 24th, 2021 from an attorney declining to represent him in 3 numbered civil cases in federal district court. In addition, Mr. Heidi concedes that he did not file any timely facility claims relating to the alleged incidents. He does state that the claim regarding the 2016 incident was untimely because of his stay in the clinic and ADSEG, but he also states that he believes he did file injury claims, but they were dismissed or lost. Records indicate that he was able to file a property claim about an unrelated property issue in 2017, so he has had the ability to file. Rule 2 of the Joint Committee provides that the claimant should first exhaust administrative and judicial remedies. It appears that Mr. Heidi has exhausted neither. As such, his claim is subject to dismissal pursuant to Rule 2 of this committee. In addition to the 2 alleged incidents referenced in his facility claim against Lansing, he states in his current claim that in 2019 or 2020, another inmate at El Dorado headbutted him while the inmate was being escorted by staff. No documentation of the alleged incidents in 2019 or 2020 was found at either facility. With regard to the 2016 incident at Lansing, there is documentation showing that there was a central monitor put in place between these 2 inmates. There's also a disciplinary report charging Mr. Heidi with fighting with this inmate on the date alleged. He pled guilty to that charge as shown in the disciplinary.
I object to that. That's not correct.
It's attached, the disciplinary report is attached to our response.
Mr. Heidi, let's let her finish her testimony, okay? Then we'll come back to you.
2 of these alleged incidents are completely unsubstantiated, and there's no indication of staff involvement in the 2016 incident at Lansing. There's no allegation that staff knew or should have known that the other inmate posed a danger to Mr. Heidi or that the incident was not handled properly when it occurred. Moreover, Mr. Heidi now describes it as an attack, but he pled guilty to fighting in the disciplinary case stemming from the incident. There's no showing that any alleged loss directly resulted from staff negligence or that he's entitled to the relief that he seeks. We are recommending that the claim be dismissed pursuant to Rule 2, or if not that, then that it be denied.
Thank you. Committee, do you have any?
Of course.
One moment, Mr. Heidi. Committee, do you have any questions of Libby? All right. Mr. Heidi, what did you want to say?
The day of the battery, I did not get a fighting DR because it was not a fight. how could I get a battery, or how could I be fighting when there was a battery on me? And it was not documented that day, and that was later fabricated by DOC.
Thank you, Mr. Heidi. Committee, do you have any questions? Any further questions? Very good. Mr. Heidi, thank you so much for your testimony today, actually, we're not a court, it wasn't testimony, for your explanation of your claim. And we will get back to you within 21 days as to our finding. Thank you.
May I add anything else?
Sure, go ahead.
Okay. I did file legal legislation, or whatever it's called, through a civil complaint about other things, including civil rights violations and stuff, and it was dismissed. And I have documentation of that. So when the other side said I didn't do it, I did do it. I did file, and I did go through the exercise my due diligence and stuff.
Thank you. Thank you, Mr. Heidi. Appreciate that. We're going to move on to our next claimant now. Thank you so much.
Okay, bye.
Bye-bye. The next claim is 7205. It's Brian Manis, $110.91.
I would just note that my response addresses this one and his next one in one letter. So.
Oh, there's two of these. Oh, yeah, we might as well. Thank you.
Thank you for calling the El Dorado Correctional.
Please dial the extension number. Press the star. We will now connect you.
This unit, Team Hefner.
Good morning. This is the Joint Committee on Special Claims Against the State. We're looking to speak with Mr. Brian Manis, please.
Yes, ma'am. He's right here.
Thank you.
Hello?
Mr. Manis, hello. This is Senator Dietrich. I'm chair of the Committee on Special Claims Against the State. And today we're going to hear both of your claims. You have one for $110.91, and then you have another one for $60.19. So we've got you on speakerphone with the committee. We're going to ask you to tell us about those claims, even though we have all the documentation. And then we're going to ask the Department of Corrections attorney to give the department's side of this claim, both of these claims. When that's completed, the committee is going to take some time to consider your claims, and then we will get back to you within 21 days as to what we have determined. Does that make sense to you?
Yeah.
Very good. Well, we're ready for you to talk to us about both of your claims.
As soon as I got my property, I notified Unit Team Specialist Johnson down here in writing and personally about a bunch of my property missing, and my electronics and my food. And he tried getting a hold of Unit Team Barry about it, and they never did find my stuff. And then when I got to talk to the officer that packed my property out, Mr. Siness from SST, and he said he never packed my stuff out, he just inventoried it, but they let my bunkie pack it out. So they violated the IPP by that, by allowing another inmate to pack out my property. And that's with both of them because it was all in the same cell.
Thank you. Committee, do you have any questions for Mr. Manis? Okay, did you represent Humphreys? No. At this point, then, we're going to have the attorney for the Department of Corrections give us the department's response to your claims. Go ahead, Libby.
Thank you. Mr. Manis's claims stem from property loss, alleged property loss relating to a cell move at El Dorado facility. In 7205, he requests $110.91 for some personal property items, including headphones, batteries, surge protectors, sweatpants, etc. In claim 7206, he requests $60.19 for canteen items, including cookies, chips, meats, and candy bars. In both claims, he alleges that he was moved to segregation on May 25th, 2021, and that staff allowed another inmate to pack his property contrary to policy. On June 12th, he filed a facility claim where he alleged that he had reported to his unit team and he had reported the loss or the missing items to his unit team and referenced a Form 9 that is not included with Claim 7205. On June 15th, he filed a separate facility claim, and there he alleged that upon getting his property receipt from being packed out, he noticed that none of the items were in his property, along with the other items from the other property claim. Included with Claim 7206 is a Form 9 dated June 15th, 2021 to Unit Team Johnson, in which Mr. Manis requests a copy of his canteen purchase history and states that the items were not in his property. In neither claim did he allege that staff had permitted another inmate to pack his property. The facility claim responses both stated that he had signed the inventory of his property on June 3rd without noting anything missing, and the claims were denied. In his present claim, he alleges that he did report items missing to Unit Team Johnson verbally and by Form 9. In 7205, he says that he did so at the time he received his property. Facility records indicate that Mr. Manis received his property and signed the inventory on June 3rd, 2021 without noting any discrepancies. The only documentation provided indicating that he reported anything missing is a Form 9 dated 12 days after Mr. Manis took possession of his property. As such, there's no way to establish that the claimed items were among his property when staff packed it or that staff ever had possession of them. So we are recommending denial of the claim.
Thank you. Committee, do you have any questions of the attorney, Libby? Mr. Manis, is there anything else you want to tell us about your claims?
Nah, that's pretty much it.
Okay, thank you very much. We appreciate you spending time with us today. We'll get back to you within 21 days about your claim.
Thank you.
Thank you. Have a good day.
Yeah.
Okay, all right. Ma'am, was that on both claims?
That was on both claims.
Okay, I just wanted to make sure before we hang up.
Thank you.
Thank you, ma'am. Bye-bye.
Thank you very much. We've got 10 minutes. Do you want to take action on the claims we've heard before we lose track of what we've heard? Easy to do. Let's start with claim number 7163, which was the gold chain and crucifix, which did not have any additional information. I'll take a motion. Representative Miller.
Move to approve the claim in the amount of $50.
The maximum is allowed is 20.
No, that's their policy, that's not ours.
50?
We took it because we suspected it was worth more than $50. That was the reason we confiscated it, because it exceeded the amount that, and at the time we took it, we valued it more than $50. Had he produced today some evidence of what the actual cost was, I would have moved to approve that. $50.
Okay, we have a motion. Do we have a second for $50? Okay, Representative Ralph seconds. Do we have any discussion? All right, all those in favor of approving the claim 7163 for $50, signify by saying aye.
Aye.
Any opposed? Okay, claim approved. Thank you. I think he'll be pleased. Claim number 7204, this is the one that we just heard it from a few minutes ago with Mr. Heidi. The recommendation was that he did not exhaust all judicial efforts.
Move to, I think what in the language, dismiss it pursuant to Rule 2 without prejudice.
Without prejudice. Do I have a second?
Even though I think he's well beyond his statutes anyway, but I think that's normally been our motion.
Do I have a second? Senator Straub? Yeah, is there any discussion? All those in favor of denying or dismissing without prejudice per Rule 2, claim number 7204, please signify by saying aye.
Aye.
Any opposed? Okay, very good. Thank you so much. Claim number, we've got 7205 and 7206. For the minutes, do you want us to take them separately? Does it matter?
No, ma'am. If there's a motion that involves, it would just, if the motion could just identify both claims, if the motion is a combination.
I'll take a motion either way, either individually or with both.
Madam Chair, I'd move to deny claim number
0.
7205, and then separately as well a denial of claim number 7206.
Do I have a second? Anybody second? Representative Samsel. Is there any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay. The claims 7205 and 7206 are denied. Okay, we are ready for claim 7202, and we're still ahead of time. All's well. This is claim Randy Herbal.
Tom, may I help you?
Yes, good morning. This is the Joint Committee on Special Claims Against the State. May we please speak with Randy Herbal?
Well, let me see if he's out here. Just a second. He's not quite made it down here yet.
Will he be long? Can we've got a couple minutes we can wait.
Okay, that'll be fine. I'll see if I can't track him down. Just a second.
Okay. Certainly, Representative Humphries, while we're waiting, yes.
Thank you. Just out of curiosity, how were the inmates notified of our decision? What's the procedure?
Merle will answer that for you.
Okay.
Yes, Madam Chair, Representative Humphries. So once this hearing is over, you try to within about a week or two, they are sent through certified mail notification of the outcome of this meeting. So that might be they're notified whether it's denied, whether it's awarded or recommended a lesser amount, or they're notified that the item is carried over. If the committee has stated they want some specific additional information, we try to note that in that notification. Some specific information that they want to hear at the next meeting, we try to include that in that notification.
I have Mr. Herbal here.
Thank you.
Thank you. Did that answer your question, Representative Humphries? Thank you very much. We're ready for Mr. Herbal when he's ready.
I'm ready.
Mr. Herbal, this is Senator Diedrich. I'm chair of the Joint Committee on Special Claims Against the State, and the committee is hearing your claim for $13.66. And you're on speakerphone with the committee. Can you hear me?
Yes.
Very good. So the committee has all the documentation that you submitted. We're going to ask you to tell us about that claim in just a minute. After you're done explaining the claim, we're going to ask the attorney for the Department of Corrections to also tell us what the department's position is. When that's completed, the committee will take some time to consider your claim, and then we will let you know in 21 days what we decided about your claim. Does that make sense to you?
Yes.
Very good. So could you go ahead and just tell us about your claim in your own words?
Okay, on the night in July, 7 p.m., Adam shook me down, and he seized my radio because it was altered. He told me if I can prove that I bought the radio, to give it back to me. So the next day I went to the unit team, got a copy of my receipt, but they already destroyed the radio before I had a chance to show them the receipt.
That's pretty much it.
Okay, thank you. Thank you very much.
Welcome.
Mr. Herbal. At this point, we'll ask the attorney, Libby, to talk to us about the department's position. Libby, go ahead.
Thank you. Mr. Herbal's radio was confiscated July 6th of 2020. July 29th, he filed a facility claim. He said staff conducting the shakedown removed the radio because it had no name or number on it. He said he told the officer he had purchased the radio in 2012 for $13.66. The claim response said that the radio had been destroyed on August 9th because it was altered and had another offender's name and number partially scratched out on the back. In his present claim, he complains about not receiving adequate assistance in obtaining a copy of the purchase receipt for his radio. He did, however, ultimately obtain one. It is attached to his claim, a copy of a receipt dated July 5th, 2011 for a ClearTunes radio valued at $13.66. However, also attached to his claim are a shakedown report indicating that the radio was seized and a property removal form describing the radio as ClearTunes altered, not offenders. KAR 445111 provides that altered property is contraband, and if an inmate is found in possession of contraband, it shall be confiscated and the inmate shall forfeit all rights to the item. Mr. Herbal purchased a ClearTunes radio in 2011, but the radio that was found in his possession in 2020 was altered. It may or may not have been the same one that he purchased in 2011, but he's not entitled to compensation for property that has become contraband. His claimed loss is not the direct result of staff negligence, so we recommend that the claim be denied.
Thank you, committee. Do you have any questions of either Mr. Herbal or the staff attorney? Yes, Representative Humphries.
Thank you, Madam Chair. So he mentions that someone, I think he maybe said Adam, or someone Adams, told him that if he could prove that he had the receipt, then he would get his radio back. Do you know anything about that?
I don't know about that. I know that the documentation says it's altered. It had another inmate's name and number scratched out, partially scratched out.
And what did you mean clear? You said something clear, not offender altered. I mean, I didn't understand.
Sorry, on the shakedown report, it's attached, I think, to his claim. It says it's basically a document that says, here's the things we seized, and here's a description of them or why we were seizing them. For the radio, it said, it's a ClearTunes radio, altered. It's not the offenders. That's what was written on the seizure form for the radio.
Okay.
And then there's a separate process for ultimately disposing of it, and that described it more clearly as saying it had another offender's name and number partially scratched out.
Yeah, and since it was destroyed, then it's kind of hard to go back and see, you know, what the situation was. Thank you. Thank you, Madam Chair.
Thank you. Any other questions for either Mr. Herbal or Libby? Very good. I'm sorry, Representative Miller.
For the claimant, sir, how do you pronounce your last name?
Herbal.
Herbal.
Okay, thank you.
Yes, sir.
Thank you very much. Mr. Herbal, thank you. We are finished now with your claim. We're going to move on to our next one.
All right, well, thank you.
Thank you very much. Next, we'll do claim number 7203, Mr. Thomas, Terrell Thomas, $1 million. Personal injury.
This is Champ.
Good morning. This is the Joint Committee on Special Claims Against the State. May we please speak with Mr. Terrell Thomas?
Yes, I believe he should be in the building. I believe I told him 11:40. Thomas, 116429. Thomas, 116429. Please report to the D2 Unit Team Office. Hopefully he's not still at lunch.
We've got a couple of minutes.
Okay. I have Mr. Thomas here.
Thank you.
I'm going to put it on speakerphone now.
Mr. Thomas?
Yes, ma'am.
Hi, this is Senator Dietrich. I'm the chair of the Joint Committee on Special Claims in the state legislature. We're hearing your claim for personal injury of $1 million today. You are on speakerphone with the committee. We're going to ask you to tell us, to describe your claim to us, even though we have all the documentation in front of us. And then we're going to ask the Department of Corrections to also give us their position on your claim. When that's completed, the committee will take some time to consider your claim, and then we will give you a decision within 21 days. Do you understand?
Yes, ma'am.
Good. So go ahead and tell us about your claim.
Well, this happened on March 14th of 2001, this year, and there was a response call to D1 in Hutchinson Correctional Facility due to an issue where I had passed out, and upon being taken to the clinic to get evaluated is when force was brought to me that was uncruel and punishment, you know what I mean, that I felt that was unnecessary and unprofessional. And I just, you know what I'm saying, went through the proper procedures to fill out the paperwork because I felt like it was not necessary because I wasn't a threat to the staff or to myself at that point in time. And I actually, you know, a lot of the statements in the files and reports of the medical staff and the non-grievances and reports were kind of false. It wasn't all totally true, and that's why I sent the documents and true facts of what happened and what occurred on that date and those times.
Thank you, Mr. Thomas. Appreciate that. Committee, do you have any questions for Mr. Thomas? If not, Libby Snyder from the Department of Corrections will ask you to give the Corrections Department's position.
Thank you. Mr. Thomas's claim arises out of a use of force incident occurring in March of this year. On March 24th, he filed a facility claim for $5,000 relating to these allegations. There, he stated that he was put into restraints and placed in a wheelchair to be taken to the clinic. When officers would not tell him where he was being taken, he says he put his feet down, but the footrests were not in place. He argued that if they had been, there would have been no reason for the events that took place next, resulting in his injuries. He stated that excessive force was used as they were leaving the cell house. The facility claim response explained that Mr. Thomas was found lying on the floor outside of a cell that was not his. He refused to comply with orders to return to his cell. When staff attempted to assist him, he became combative, and staff used the minimal amount of force to gain compliance. Mr. Thomas later admitted to medical staff that he had taken a mood-altering substance. The response went on to note that Mr. Thomas received immediate medical assistance, and the only issue noted was an abrasion on his cheek. He denied any other issues, and medical staff noted that he was under the influence. A week later, he reported issues with his wrist, and medical staff noted nothing visually wrong with it, but they did continue to address his concerns. With his present claim, he provides a complaint response regarding his medical treatment after the incident. The response explains that the Medical Health Authority reviewed the matter and determined that he had presented to the clinic on March 17th wanting his injuries documented after a use of force. He had superficial abrasions to a left rib, back of his right shoulder, left flank, and left cheek. There was no deformity or swelling noted in his right hand, and he had full range of motion. March 22nd, he returned to the clinic supporting his right arm with his left hand, and he reported numbness and pain, but he had full range of motion and good capillary refill. He had a 2 by 2 centimeter laceration that was healing, and he declined pain medication. When he was seen by the physician on March 23rd, he had full range of motion with slight swelling. No weaknesses or neurodeficits were noted, and he was advised to do grip strengthening exercises. The clinical reviewer concluded that Mr. Thomas had some residual hand pain that appeared to be resolving. Facility staff responding to his present claim also noted that he received a disciplinary charge for being in an altered state at the time of the incident, and he pled guilty to the charge on March 16th of 2021. Facility staff also reviewed the use of force report and security video of the incident, and they determined that they showed that the claimant is clearly under the influence of some substance. He fights with staff when they are trying to change wheelchairs for the purpose of transporting him to the clinic. He was placed on the floor to gain control of him, and the overall process was careful, professional, and reflected no unreasonable use of force. It is not clear whether his hand/wrist issue was solely the result of physical contact on this date or whether it may have pre-existed the event. The videos also document that it was a very short amount of time that he was actually in restraints. According to the reports, he was under the influence of an unknown substance, and a medical response was called. When the response team arrived, he was placed in hand restraints and then a wheelchair to be taken to the clinic for assessment. Mr. Thomas actively resisted officers by trying to stand up from the wheelchair, and he tried to kick officers while ankle restraints were being applied. When he continued to resist, following a warning, a handheld electronic device was applied twice to his left side for about 5 seconds each time. He was then placed on the ground and his legs crossed while restraints were applied, and he was placed in a stair chair and taken to the clinic to be seen. He was in hand and ankle restraints for less than 10 minutes. Mr. Thomas was injured during use of force necessitated by his combative behavior with staff who were attempting to assist him when he was found to be incoherent and under the influence of an unknown substance. All reports and review of security video indicate that a reasonable amount of force was used to gain compliance, and Mr. Thomas was immediately seen by medical personnel. It appeared that he sustained minor injuries during the incident, but any injury he suffered was a result of his own conduct and not the direct result of staff negligence, and we recommend denial of the claim.
Thank you, Libby. Committee, do you have any questions of either the claimant, Mr. Thomas, or Libby Snyder from Department of Corrections? Very good. Mr. Thomas, is there anything else you want to add?
As far as what I just heard, like I wasn't aware of, you know what I'm saying, all this extra information that I was kicking and I was being combative towards officers. I mean, that's all new to me, but I mean, I have no questions, so
Thank you. Thank you very much. Committee, there are no questions. We'll move on to the next claim. Thank you, Mr. Thomas. Appreciate you talking to us today. Oh, I'm sorry. Representative Miller does have a question.
Or Ms. Snyder, are they given an opportunity to see the video as well?
I don't know about that. I've not heard of that, but he did get a facility response which had all this summarized.
I understand, but if he was able to see the video, it might eliminate a lot of the debate. If
That's a possibility.
He claims one version of things, and when you show him the video, the video pretty much speaks for what happened. It seemed to me it'd be a lot simpler way possibly to resolve these things if they had a chance to view their own actions. Just a suggestion. Thank you.
Share that.
Thank you very much. Any other questions or comments? Thank you, Mr. Thomas. We're going to end this discussion now, move on to our next claim.
Oh, can I ask him one more question?
Sure.
Okay, I just feel like, okay, he said that the video would explain what happened, and it would explain a lot of things, but to me, I couldn't have caused these injuries to myself. Being in restraints.
Okay, thank you. Thank you for that. Appreciate it. Bye-bye. Have a good day. Our next claim number is 7198. It's a carryover. Mr. Garcia. Property loss, $236.
You have reached the Lansing Correctional Facility. If you know your party's extension. Lansing Correctional Facility.
Good morning. This is the Joint Committee on Special Claims Against the State. I'm trying to reach a Mr. Ray Garcia.
I see an employee here.
No, an inmate. For some reason, it didn't take me to the prompt for the extension. It's looking for 58344 is the extension.
Okay, just a moment, please.
Thank you.
Haley Knudsen.
Can't take your call now. At the tone,
Sure. Yes.
You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and listen to the prompt. Please dial the extension number, press the star key to start over. We will now connect you.
hi, this is Rachel Graham, the IPO. I have stepped away from my desk at the moment, but if you leave your name and a deep
Do you want to move on to 7192 maybe? And we'll come back maybe to 7198. So we're going to move on to 7192. This was a carryover from personal injury, 7.5 million.
Telephone number 620-625-7759.
You've reached the voicemail of Michael Bonner, Check Corrections Counselor 2.
Well, we have 2 claims before lunch that we're not able to connect with the facilities. Do you want to, let's go ahead and take action on 7202 and 7203, and maybe when we come back from lunch, we'll be able to connect with these 2 facilities. So claim number 7202, that was Mr. Herbal, altered property.
Move to deny that claim.
Do I have a second? Representative Samsel? Are there any questions about this claim? If not, all those in favor of denying the claim, please signify by saying aye. Aye. Any opposed? Okay, claim denied. That's 7202. And the next one was 7203. That's Mr. Thomas.
Madam Chair, I move to dismiss claim number 7203 pursuant to Rule 2 of the committee without prejudice.
A second? Anyone have a second? Representative Samsel? Is there any discussion on this personal injury claim? If not, all those that are in favor of dismissing the This claim, did you say with prejudice? Without prejudice, thank you. Per Rule 2, claim number 7203, please signify by saying aye. Aye. Any opposed? Okay. Claim is dismissed without prejudice. Okay. Do you want to try one more time or just break? Okay, let's try Garcia one more time, and that's claim 7198.
You have reached the Lansing Correctional Facility. If you know your party's extension, please dial the extension number, press the star. There were no matches. Please dial the extension number, press the star key to start over. There were no matches. Please dial the extension number, press the star key to start over.
Yeah.
You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and please dial the extension number, press the star key to start over. We will now connect you.
Haley Knudsen.
Can't take your call now.
Still on.
You have reached the Lansing Correctional Facility. If you know your please dial the extension number, press the star key to start over. We will now connect you.
Hi, this is Rachel Graham, the IPO. I have stepped away from my desk.
Try Mr. Payton. One more time, 719. Claim number 7192, we're going to see if we can't connect on 7192.
Telephone number 620-625-7759.
It is mine.
Committee, we have a couple of options. We can leave now for lunch and come back a few minutes early and see if we can't connect with these last two claimants. We do have things we have to do after lunch. We have Department of Revenue that will be here talking to us about the motor fuel tax. We need to approve our minutes. Would you be willing to come back instead of at 1:30, come back at 1:20? Right now, come back at 1:20? And then we'll try these last two claims that we couldn't get to now. Okay, so committee, we will break for lunch. It's about I don't know, 5 till 12, 11:55, and we'll come back at 1:20. And we'll start with claim number 7198. Thank you. Committee is on recess until 1:20. Committee, we're going to call ourselves back into session here. We have a claimant that we postponed until after lunch. That's claim number 7198, Mr. Garcia.
Number, press the star key to start over. There were no matches. Please dial the extension number, press the star key to start over. You have reached the Lansing Correctional Facility. If you know your party's extension, please dial the extension number, press the star key to start over. There were no matches. Please dial the extension number, press the star key to start over. Please dial the extension number. You have reached the Lansing Correctional Facility. Please dial the extension number, press the star key to... We will now connect you.
Haley Knudsen.
Can't take your call now. You have reached the Lansing Correctional Facility. If you know your party's extension, please dial the extension number, press the star key to start over. We will now connect you.
Hi, this is Rachel Graham, the IPO. I have stepped away from my desk at the moment, but if you
Would you like to try Mr. Payton then? Claim number 7192. See if we can get in touch with someone there.
Hello?
Yes, good afternoon. This is the Joint Committee on Special Claims Against the State. We're looking for Mr. Darrell Payton, please.
This is him speaking.
Mr. Payton?
Yeah.
Hi, this is Senator Dietrich. I'm chair of the Joint Committee on Special Claims in the State Legislature. So we're hearing your claim for a personal injury for $7.5 million. Okay, so you are on speakerphone with the committee. So we've got all of your documentation, and we're going to ask you in just a minute to give us additional information that you'd like to share with us about your claim. When you're finished, we're going to hear from the Department of Corrections Attorney Libby Snyder, and she's going to give us the department's position. We may ask you some questions, and then when we're all finished today, in about 21 days, we will give you a determination on your claim. Do you understand?
Mm-hmm.
Very good. Is there something you would like to tell us now about your claim?
No, other than the fact that the infection keeps
reoccurring. In fact, it's came back since I submitted the last documentation to you guys.
Okay, thank you for that. The one question I think I would have is, do you have any medical malpractice suits filed in court?
No, ma'am. Not at this time, no.
Okay, thank you very much. So, Mr. Payton, we have everything that you've given us, all of your medical documentation, your handwritten notes, and now we're going to hear from the Department of Corrections attorney, unless committee, you have questions of Mr. Payton? Does anyone have any questions of Mr. Payton? Libby, would you like to present the department's position?
Thank you. Mr. Payton says that in October of 2020, while incarcerated at the Larned Correctional Mental Health Facility, he was diagnosed with a hernia and a large hydrocele. He states that he was referred to a specialist who diagnosed him with an inguinal hernia and hydrocele and scheduled him for surgery. During the surgery, it was determined that there was no hernia, and Mr. Payton complains that there were no MRI or CT scans done prior to the surgery to confirm the diagnosis. In addition, he complains that the surgery to remove the hydrocele was ineffective and resulted in infection and further complications. He alleges medical malpractice based on failure to correctly diagnose and treat him, and he states that the long-term effects on him are uncertain. He did file a facility claim, and that was denied based on a lack of showing of any negligence on the part of any state agency or employee. In his facility claim and in his present claim, he states that he would like to preserve any and all rights he may have to properly litigate the matter. And we do submit that based on Rule 2, he has not exhausted judicial remedies, and perhaps Rule 2 dismissal may be appropriate for the claim. In addition, Mr. Payton's allegations all concern healthcare decisions made by Centurion staff or other medical providers. There's no allegation and no showing of negligence on the part of any agency staff that any alleged loss was the direct result of staff negligence. So our recommendation is that it be dismissed pursuant to Rule 2, and that if it's not dismissed, it be denied.
Thank you. Committee, do you have any questions of the attorney for the Department of Corrections, Representative Ralph?
Thank you, Madam Chair. I was wondering, I don't recall what the reasoning was. What information were we looking for? Did we ask for last time in the note? I can't remember the specific of this. Libby, do you remember?
I don't think we've heard this one before. This is one that I asked for carryover because I had just received it not too long before the hearings.
Okay, we had not heard this before.
Okay, so there was a little note on here that said we'd ask for information. Actually, this was just one that I didn't recall it, so we just hadn't heard this, and this was late getting to you is why we've got it now.
That's the only reason I knew of it.
That makes more sense. Thank you.
Very good. Any other questions of either Mr. Payton or the attorney? No? Mr. Payton, is there anything else you'd like to say to us?
No, ma'am.
Thank you very much. We'll be in touch within the next 21 days as to our decision.
Okay.
Thank you. Do you want to try 7198 now? Okay.
Good afternoon. This is the Joint Committee on Special Claims Against the State.
This is Rachel Graham. You have the wrong extension, ma'am. He's here at the facility. He's in our office. He's just had another telephone.
Okay.
So if you want to call I'm sorry.
Yes, what's that extension, please? Thank you.
58804.
We have tried that extension, and it gives us no extension found.
Hold on let me make sure that it's the right one. Hold on.
Looking at claim number 7198 if we can connect.
Hello.
Yes.
Hey, can I call you from the phone if the extension's not working?
Yes, sure, you can call back.
Okay, and just to confirm, the phone number is 785-296-7176.
Correct. How long do you think it would take to call back?
I'm walking to the phone right now, and I'll call you.
Okay, thank you.
Bye-bye.
So this will be claim number 7198, Mr. Garcia.
Yeah, I just wanted to clarify one matter, ma'am, regarding the note on claim 7192, and I realize you're talking about a different claim, so I can wait if you want.
No, go ahead.
There was a note that the committee did actually request the claimant provide some additional information regarding medical treatment. So he had some procedures done related to a hernia. It's related to some treatment he received at the Hoisington Hospital. He indicated he had some additional material, and he had submitted some additional material.
We heard that last meeting.
You did hear that? Yeah, yes.
Very good. Thank you.
To be clear, I think you heard from the inmate, and I think as Department of Corrections indicated, they were requesting additional time to investigate. So you probably heard one side and have not heard the other.
Thank you. Thank you very much.
Good afternoon, Joint Committee on Special Claims Against the State.
Yes, here, I have Garcia here.
Perfect, thank you.
Mr. Garcia?
Yeah.
Hi, this is Senator Dietrich. I'm the chair of the Joint Committee on Special Claims Against the State. We have your claim in front of us. It's for $236.47. And you are on speakerphone with the committee. So we have all the documentation of your claim, but we're going to ask you to explain to us, if you want to, any other details about that claim. As soon as you're finished, then we have the attorney for the Department of Corrections here, who's also going to present the department's side of your claim. And when that's completed, then we may ask you a few questions, but we will decide and get back to you within the next 21 days as to what we decided regarding your claim. Do you understand that?
Yes, I do.
Very good. Would you like to explain to us what your claim is all about?
Yeah, I was out in my day room time, and when they called dinner, I went to I was like looked up at my cell and noticed my light was on, and there was a guy standing there and said, "Hey, would you shut my door?" And he shut my door, and I went to chow, and while I was eating chow, some dude came from behind me and attacked me, and I had to go to the infirmary because I had trouble breathing, and they wanted to observe me for 24 hours, and they had just took x-rays of my rib, and my rib was fractured, and I had lost a tooth, and my face was swollen in. And when I got back off from the infirmary, went to my unit, and they gave me I went to go get my property. I noticed that a lot of property was missing, and so I filed the property claim. And if you look on the claim, the property claim that the Hartley did, the investigator, but before I get to that, this guy attacked me was from the same unit I was in, and he lived in A5 232. I lived across from him, which is across the day room, which is 231 A5, and this right here where it says conclusions made. After investigating the property claim I have determined you were moved from A5 231 to DD13 on that's the infirmary room on 5/9/2021 because of an I can't pronounce some words altercation in the chow hall. You were the only inmate that lived inside of the room at the time the property was removed from the room A5 232. I have reviewed the cameras and have spoken with the officers that were involved with pulling and packing the property. Staff have stated that they do not recall seeing any of the listed missing items, and everything in the room was removed and inventoried for the inmate to receive. And he denied the claim, but if you see what I'm saying, he viewed the cameras from A5 232, and he asked the officers, and they said no, nothing of this was in that room. But I lived in A5 231, and he checked on the wrong side of the unit and checked a different room and was asking the officers for that room, which that's where that inmate lived that attacked me. And it also, I don't know if I documented it into you guys, but there could have been an inmate in my room at the time when I was in my day room time too, because I had went outside, and I can't view my room from outside in the patio area. And these guys that live next door to me always have the door and have a lot of traffic over there. So, and these officers that don't work in the units on a daily basis do open up doors that an inmate could say, hey, will you open my door? And they believe that's his cell, because in the computer, when they open these doors up, they don't have names on them. They just have cell numbers. And an inmate can claim he lives there and don't even live there, and this officer is going to take his word he lives there and don't even look on the roster sheet to see if that guy lives there or show him his ID. They just open these doors up. So that's possibly how my room got raided. But I had money then, and it wasn't like I'm trying to claim something that I'm trying to get money to be placed on my books. I don't sell my stuff. I don't, my people just bought me a box. And that stuff, I just trusted no one was going to go in my room and steal my stuff, but I was wrong. But that's what my claim is, that the investigator checked the cameras in the wrong area of the cell house, in the wrong cell, and asked officers if that property was in 232. He didn't ask for 231, which that's the cell I lived in.
Thank you, Mr. Garcia. Does anybody have
Yep.
questions of our claimant? Okay, very good. Mr. Garcia, we're going to hear from the Department of Corrections attorney now.
All right.
You can share now.
Thank you. Mr. Garcia did file a facility claim regarding this, and in the facility claim, he stated that staff had allowed other inmates into the cell, or they had allowed other inmates to carry his property down to the officers. The facility claim investigator determined that he had been moved from A5 231 on May 9th of 2021. He was the only person housed in the cell at the time. The investigator reviewed security footage and spoke with the officers who packed Mr. Garcia's property. They stated they removed everything in the cell and did not recall seeing any of the items that Mr. Garcia claimed were lost. In his present claim, Mr. Garcia asserts that staff investigating the facility claim reviewed the wrong security footage. The facility claim response notes that Mr. Garcia was moved from cell 231, but then states that he was the only person living in 232 at the time. The claim investigator was asked about Mr. Garcia's current claim and stated that the reference to 232 was a typographical error in his report and that he reviewed the correct video. He stated, in fact, he had gone back and reviewed the security footage a second time, and Mr. Garcia's cell door remained secured until staff entered to gather the property. Mr. Garcia signed inventory pages on May 9th and May 17th, certifying that the inventory was accurate and that all listed property was returned to him. He did not note anything missing either time. We are recommending that the claim be denied.
Thank you. Committee, do you have any questions of Libby? Okay, thank you so much. And Mr. Garcia, we'll get back to you within 21 days with our finding.
Hey, can I say something else?
Yes, you may.
Okay. Now, when we sign our inventories, when we pick up our property, they tell us if anything's missing, we're supposed to file a property claim, and that's what I did. I didn't sign it that everything was there. But that's everything that was they packed out at that time was there. I had showed receipts. I just was only in that unit for 11 days from a different unit I was in, and that stuff kind of just disappeared within 11 days. But I'm just saying that that's what the inventory she's saying is, that I claimed that I signed everything was there that they packed out. You know, not this stuff it's missing. You know, I just want to make sure you had an understanding of between the difference of what was on that property, the inventory property sheet. That's what the officers just had in that room at the time and packed out. But the stuff that became missing was the stuff that that I had receipts and I still had in that room. And however, that room someone got in that room and took that stuff. So that should have been on that inventory sheet, and it wasn't. So I filed the property claim and I had the proof that this stuff was in there. So just so we have an understanding, and plus, they never told me that they reviewed the camera again, and they didn't say on this sheet that he made a typo error about the cell locations. You see what I'm saying? So then now, okay, that's all I wanted to really tell you. I wanted you to understand that they're trying to loop around the holes, you know, that they messed up and did the incorrect investigation. You don't got no paperwork, and I don't got no paperwork that they redid this investigation. That I still got the same paper that they gave me on 5/24/2021, that this states that they didn't go back and review the cameras, and that the property claim officer didn't state on another paper that, hey, I made an error of putting the wrong cell number, you know, on there. He just stated that he went and viewed a camera on a cell that I wasn't in, or state where this other inmate was. You see what I'm saying?
I do.
So I just want to make sure. Okay, I appreciate your time, and I just wanted to have you understand I don't got to try to rip off the state. You know, I mean, I don't buy my stuff just to be buying it so someone can steal it and not file a property claim. You know, our property that we have is a very valuable thing, and I wasn't in the wrong of, you know, I wasn't me attacked anybody. If somebody else attacked me and they got my property, that's how they do stuff, you know. And I ain't gonna lie about how they open doors up, you know, and then people don't live there. But that's all I have to say. Appreciate you letting me say that.
Thank you. Thank you,
I
Mr.
speak the truth.
Thank you, Mr. Garcia. Appreciate
All right.
the explanation.
Okay.
We do have a question. Representative Humphreys?
Thank you, Madam Chair. I don't find the date that the altercation happened in the dining room. Do you know what date that was, Mr. Garcia?
Yeah, it was on Mother's Day. It was on 5/9/2021, right where they say that conclusions made.
Mm-hmm.
It says after investigating the property claim I have done, mine, you were moved from A5/2/31 to DD 13 on 5/9/2021. It happened that same day. I went to the infirmary. That's what DD 13 stands for. That's a cell.
Okay, I see. And so maybe this would be a clarification from the Department of Corrections, if I may. Thank you, Madam Chair. So I'm looking at the memo from Kay Hartley, and it says on 5/04/21, inmate Garcia submitted a property claim for the following items. So is that a,
I noticed. Yeah, I noticed that too. That's the wrong date he made, because this happened on the 9th.
Okay. And when did you make?
Yeah, I forgot to bring that up.
Mm-hmm. Okay. And you made your first claim on the 18th, is that right?
Yes, I did.
Okay. Thank you.
That's when yep.
Okay. Thank you, Mr. Garcia. Thank you, Madam Chair.
Thank you.
Thank you.
Good. Any other questions, committee? Did you have anything to add, Libby? Are you good? Okay. Very good. Thank you all. We will now move on to the next item on our agenda, which is approval of the minutes. Hopefully you may have had a chance to take a look at that. Those are our minutes from the meeting on September 23rd. I know that's been a while. I'll give you a second. Have you all had a chance to review those? If yes, I would take a motion to approve the minutes. Anyone? Representative Samsel moves. Do I have a second? Senator Stubbs seconds. Any corrections or discussion? Not. All those in favor of approving the minutes from September 23rd signify by saying aye. Aye. Any opposed? Okay, minutes are approved. Thank you. The next item on our agenda is the review of motor fuel tax refunds. And we have someone from Department of Revenue to visit with us. Are you Terry Agnew? Sure am. Hi, Terry. Welcome to the committee.
Thank you. Good afternoon.
Is the microphone on? Is the blue light on?
It's red. Can you hear
Red.
me okay?
Okay.
Take my mask off since it doesn't look like it's okay if I have it off up here. Good afternoon. It's kind of nice to come over here. I haven't had to come over here for a couple of years, so kind of got out of this.
We can't say the same, but.
True, true. What we brought forward, like we do every year, are the legislative claims, where I'll just give you a little background about the refund process. Any taxpayer who buys fuel with the tax on it and then uses it in an off-road manner is therefore entitled to have that tax money back. So a good example would be farm equipment. You have to pay the tax on it, and then you're going to use it off-road, so you can get the tax back. As long as they keep track of all their gallons that they purchase and use off-road, we're going to give them back that money. Now, statute has it, we give them 1 year from the date that the fuel is purchased to the day that they make their claim.
If you don't mind, we'll answer
fine.
that.
No problem.
Do you need to answer it?
Good afternoon. This is the Joint Committee on Special Claims Against the State. Who's speaking?
Hi, my name is Haley Knutson, and I have Ray Garcia here. I've been advised that maybe the service was lost. Is that accurate?
No, we finished his claim.
Okay, you're all done.
Thank you.
Thank you.
So sorry. Go ahead.
Oh, no problem. Like I said, they have 1 year to make that claim. If they miss the year, we are gracious enough to give them an additional 2 years to make that claim, and that's the dollar amount that comes before you guys today. Are people who waited too long to make that claim, and then here's their claim of what they applied for. That's usually all I say. Do you guys have any questions?
If you don't mind, I just might ask you, you verified these are accurate amounts.
Absolutely.
Got the records.
That is part of our process. After this process actually is the most manual, tedious process. We take every single fuel receipt that they send in to us, and we've had boxes full. We have to verify the date it's purchased, that it was purchased here in Kansas, and then various other records if they don't have original fuel receipts. So yeah, everything, to the best of our ability, we believe they are true and good claims.
And would you say from your experience that the amount that we're being asked to approve is pretty typical?
Yes, it is. I usually go over and do a running total of our claims every year. I'm always trying to reduce those numbers by educating the customer, of course. So I kind of keep a tally of the numbers I've done over the years. And this year we're at about 29,000, which is just a little up from last year, but it's below the average overall.
Committee questions? Senator Haley.
Thank you, Madam Chair. Is there any amelioration if someone doesn't file within that year, if it's in the outlying year, year 2 or year 3, that they get not as much of a refund, or is there any incentive to keep within that 1 year requirement?
Well, yes, we actually take, before we even give the information to you guys, we've taken out 10%. So they do lose 10% or $25, whichever's greater.
Each year, so.
Yeah. Well, no, it would just be once. So if they've missed claiming for the last couple of years, it's just going to be taken out of the overall amount. So it's just one time. Doesn't matter how many years old it is.
Okay, and if it is year 3, they're out of
No,
luck.
that's where we actually do cut them off.
Have you had anybody come back and say, hey, you know, I had a downturn in my economy or whatever, or there's some prevailing
Yes.
reason that does happen?
Every once in a while, they will come back, but then we just explain the process. Statute, it's 1 year, and then we actually give you an extra 2 years. Never really had anybody be too upset. I think they understand.
Thank you, Madam Chair.
Any other questions? So you're going to be asking us to approve the $29,457.39 in motor fuel tax refunds from your motor vehicle fuel tax account?
Right, correct.
Very good. Okay, thank you.
Okay, thank you.
Appreciate you being here.
No problem.
Do you need us to do that right now, or can we come back to that in the order of events here? Okay, very good. Thank you. Okay. Next on our agenda, we have claim number 7201. Are they prepared for us? I think we have people on WebEx perhaps.
Yes, ma'am, you do. Yeah, claim number 7201 with the claimant One Neck IT Solution against the Department of Revenue. If you'll remember, this was briefly brought up at the last committee meeting. This is, and the claimants and the respondents may have a discussion about this, but this is sort of a sales tax refund, which conflicts with Committee Rule 6, which prohibits such sales tax refund claims for tax refunds within claiming tax beyond 3 years from the date of payment. So to consider this, the committee might consider suspending Rule 6. We do have both the claimant and the agency on the line, and they both are prepared to, if the committee would like, to initially discuss suspension of Rule 6, and then the committee can have them go into the merits of the claim, but both are prepared to do that, and I think both are on the line.
Committee, would that be beneficial to you if we heard from them, since we did talk about this at our last meeting and we wanted some additional information?
Yeah, Madam Chair, I think that'd be appropriate, probably mainly because I think it was a specific request and may even actually been mine of why we were suspending Rule 6. Not that we're against it, but since it had never come up before, what's the justification there so that we'd have that clear on the record?
Very good. Could we hear from the claimant first?
Yes, ma'am. The claimant is represented by Cheryl Solaris, tax accountant with One Neck. And Cheryl, I apologize if I mispronounced your name, but the mic is yours.
Excuse me.
Oh, yes, Representative Miller. One moment, Cheryl.
Sure.
Just so I understand, we're only hearing at this point the justification for suspending the rule, not the underlying claim.
Well, I think the underlying claim is attached to that, why we would suspend Rule 6. I think you're going to get information that will help you see why the request is to suspend that rule. I think you're going to have difficulty separating those two out.
Well, you underestimate.
I may be underestimating you. I'm talking about myself. Go ahead, Cheryl.
Yes, thank you. So we can, yes, we certainly can address the suspension of Committee Rule 6. You know, our company, we work in probably 30 to 40 states for One Neck, and therefore we remit sales tax, and in some states we remit prepayments or estimated tax, and we have always looked at the prepayments a little bit differently than actual tax. We pay an amount, an estimated amount based on a previous month. And if that's not used, it would come back to our company regardless, because it's beyond, anything that's beyond the actual tax liability itself is an overage and is no longer considered a sales tax. So these overages have been sitting on the account and accumulating, and we were expecting them to come back. We also had closed the account, so no more activity was handled because of a merge. And then, everything's kind of spelled out in the letters and that. I'm just kind of giving an overview. And so we didn't feel like we had the 3-year limitation because I wanted to spend time to review to make sure when we called the state that we hadn't already received the refund. So I had to find time to look up our documents, contact different departments because, there's the billing department and the payment, people who receive payments and so forth. So that's kind of like the time that it took me to go over and do a thorough investigation on our side, reviewed all the documents, all the returns and everything to come up with the claim. But yeah, basically, we've always been given the prepayments back without a statute of limitations, working with other states. I've also noted that there was an estimate, or there was a deposit on account with another agency, the gaming agency. They returned the deposit on account because it wasn't being used. So, and then the way that we have practices in handling it in the financial, as far as how we do the accounting for it. So everything is that we look at it as not part of sales tax. It was a deposit that was above and beyond tax that was not being utilized and was just sitting on the account.
Thank you, Cheryl. Does anyone have any questions for this claimant? Okay, and there's also a written description of what she just told us, a letter from Courtney Fro. Oh, am I on? Yes. Oh, sorry, I must not have been close enough to the microphone. You have a letter from Courtney Fro who described exactly what Cheryl just told us. Thank you. Next, we have someone from the Department of Revenue as well. It's Mike Hale who would like to present information on this claim. Do we need to do, I guess it's a bit of procedure here. Do we want to deal with Rule 6 before we hear from Department of Revenue, or do we want to hear from Department of Revenue as part of the justification?
I move to suspend Rule 6.
Second in the discussion, or second to suspend Rule 6, and then Representative Ralph, you wanted to say?
I guess I was just gonna ask whether the department had a position about what, because this statute of limitations, if you will, I'm a little curious of the department's, whether it's a needed item within our rules in the first place, and maybe they can comment on that by a reference in their response here. But I was always a little curious as to why it even appeared in our rules. So I guess I'm asking, could we have some response from the department before we vote on that motion? I'm not necessarily opposed to the motion. I'd just like to hear.
And also, Senator Straub has a question, and then Mike Hale, if you're in the wings, we'd like you to pop on. Senator Straub?
Thank you, Madam Chair. Looking at the statute that was included in our documents here, it says that the customer must apply for that refund permit and include that $6 fee. The permit is valid for 3 years. Looking at the documentation from One Neck, they date clear back to January of 2013. I'm just wondering, I'm curious for the claimant, when did they apply for those refund permits, and have they reapplied every 3 years?
Could you answer that for us, Cheryl?
I was not under the understanding, because it's not a sales tax. We don't view it as a sales tax refund because it was not really, this is the payments above and beyond sales tax. So we did not view it as sales tax refund.
So,
but we were not aware of a permit that but regardless, we didn't view this as a sales tax.
you were viewing this as an estimated tax payment that you were paying in to the state, is that correct?
It's an estimate based on prior filings. However, that estimate is then used and applied to a refund. So everything beyond what say for instance, we had 6,561 for January of 2013. We actually had more paid in as an estimate. And then that amount was already applied to sales tax. So this is no longer considered sales tax. We're not asking for a sales tax refund. This is something that goes above and beyond what was paid over the sales tax.
Does that answer the question for you, Senator Straub?
Partially. Have they ever applied for that refund permit, though? Have they applied for that refund permit? I think I understand what she's saying now, that they had paid in excess and they were expecting a refund of those overages.
Cheryl, would you care to answer that? Have you ever applied for a permit?
I have not. I was not aware, no. Per se, not for that specifically.
Senator Straub?
We have permits for the sales tax accounts that we renew, but I don't remember something specifically for what she's asking me.
Thank you, Madam Chair. This might be a question for the reviser. How long has this statute been on the books? Has it changed within the last 7, 8 years, or is this kind of longstanding? I think it says KSA 79-3458.
Is that at the end, the beginning of our documents?
I think this is closer to the beginning of the documents that are in the PDF file we have.
Statute was last amended in 2004 in terms of the your specific question is the 3-year period that's.
Well, has the statute changed at all in the last decade? Would that
No, it has not.
Okay, that clarifies. So, and it's possible, I suppose, that One Neck was just not aware of the statute.
I believe that may be the case. Cheryl, did you want to say one other thing?
Yeah, and the thing is, we have tried to get this refund before. This is not our first attempt. So it may be this long because I couldn't get a response when I called the Department of Revenue. They basically would not even speak to me to try to resolve this. And I think that would have been shortly right after he just claimed it would have been within months of the supposed statute of limitations. So it seems like it's a really long time ago, but this is not the first time we have attempted to contact them to discuss this because we were not finding payment. Thank you.
Thank you, Cheryl. Representative Ralph?
The reviser, is it, the statute we were just referencing, was that a sales tax statute or a motor vehicle fuel?
Motor fuel.
Senator, was the reference that you're looking at 79-3458?
Yes, that's correct. That's on the page 354 of 458 in the documents that we received. It's in that second paragraph there.
My guess is that was in relation to the motor fuel tax refund.
Thank you.
Department of Revenue, do we have Mike Hale available?
Yes, Ms. Chair, I'm here.
Would you like to visit with us a little bit about the department's response to this? We have the written
Certainly.
document.
Yes, we sent a letter to the committee on September 14 that kind of addresses the initial inquiry, and then we did a follow-up, somewhat in response to Courtney Fro's letter of October 4. For example, they point out a deposit they had with the Racing Commission, and we're not privy to that and whether that was a tax matter or something else. So we kind of addressed that by saying that we don't have access to any of that information and it would not be appropriate for us to try and comment on that. We point this out in our September 14 letter. The first written contact we had from the claimant was, I believe, early 2019. And the overages that were being referenced were for various periods starting January 2013. And the last one was, I believe, November 2015. Whether Ms. Solaris called the department or not, I don't know. Just to be perfectly blunt, we get lots and lots of calls every day, and I wasn't prepared to address that one, but I do know the written request was in early 2019, which is well past the 3 years. Whether One Neck views these as sales taxes or not, Kansas statute, we point this out in our November 16 letter, requires that entities or businesses that have in excess of $40,000 a year and liability are to prepay taxes, just like individuals may have to pay estimated income taxes that they then can take a credit against when they file their income tax return. It's the same principle or same idea. They are, for all intents and purposes, a tax. It's just prepaid. And we rely on the taxpayer to be in charge of their own books and records. They know, for example, when they're going to go out of business, the statutes allow them 3 years to get everything together and clean up any books and records with us. We're not necessarily privy to whether they have made changes in their accounting, etc. The taxpayer bears some burden there to let us know, hey, we're going out of business and we have these overages, we'd like a refund. And we did verify for the committee, and we agree with the taxpayer that there were about $47,788 in overages. And the department has no opinion or comment on your Rule 6. That's the committee matter, but we certainly have no objections to anything that the committee wants to do with this particular claim.
Thank you, Mr. Hale. Representative Ralph, you have a comment?
Yes, thank you, Madam Chair. I'm hoping maybe this might be the resolution to this piece. I understand what Ms. Solaris was talking about, as does the rest of the committee. I think under our Rule 6, we talk about a refund for any tax paid. In this particular instance, the money that the state has right now is money that One Neck sent to the state, but it's not a tax. They didn't send us tax money. So I think actually Rule 6 doesn't even have application here because we're not doing a refund of a tax paid. They sent us some money. It's not a tax paid. We just have extra money here that they sent in advance. We probably could more artfully draw our Rule 6 to address overage for estimated tax paid if that should come up down the road. But in this particular instance, I think we just have some of their money. It's not tax money. They sent it to us. They didn't know it to us, and I think we can just handle it as a claim to us without having to suspend Rule 6, and that way, somewhere down the road, we don't end up in a procedural concern about was that appropriate or not. But it's not they didn't send us money that's a tax paid, so that would be my suggestion at this point, is that we simply approve the claim.
Representative Miller?
Actually, I see it just the opposite. I don't see the harm in suspending a rule that someone later might have said that we should have applied if we just ignore it. If we suspend the rule and it has no application, no harm, no foul.
Representative Rao?
I guess at this point, we certainly haven't ignored the rule because we just made a public record of it that will live in infamy forever on YouTube. But I don't think we ought to get hung up too long on it. If the committee wants to suspend it, I don't have a problem. I just didn't think it was necessary at that point, but it's not worth spending time on. I don't mind suspending it either.
Committee, any other thoughts? We do have a motion on the floor, which is to suspend Rule 6. We have a motion and a second. Any further discussion? All those in favor signify by saying aye. Aye. Any opposed? All right, we are going to suspend Rule 6, and then we will deal with this claim. Do you want to deal with it now, since we've got everybody on the line? Okay, I'll take a motion.
Move to approve claim number from One Neck, and it's claim number
7201.
7201.
In the amount of $47,788.56 to be paid for from the Department of Revenue's.
Yeah, I think,
Correct.
Madam Chair, if I may, if the motion would just read something like pay with existing resources, that would be sufficient.
So moved.
Second. Senator Straub, any discussion? Yes, Senator Straub.
Thank you, Madam Chair. I still would like to know if One Neck has that permit that's called out, because it does say that they have to apply for that permit. And I'm wondering if, because they didn't have that, that might have been the reason for an overage report not being sent to them, or somehow that's how we maybe got to this point. So to prevent this from happening again, maybe we need to make sure that the correct permits are applied for and everything is submitted in that timely manner. Thank you.
Do you want them to respond to that, or is that just a point of information?
Just as a point of information, thank you.
Thank you. Thank you very much. So I forgot what I was doing. Are we ready to take a vote? Okay. All those in favor of paying this claim signify by saying aye.
Aye.
Any opposed? Very good. The claim will be paid with existing funds. Thank you. We have one more claim this afternoon, 7207. That's Mr. Thomas. And as soon as we're finished with that, we need to go back and vote on these other claims. Vote on these other claims. Merle, do we?
Correct, ma'am. We started earlier with 7192 and then moved to 7198. Yes. Yep, also voted on. 7198 and 7192 are the only remaining inmate claims that have not been voted on.
Mr. Thomas, this is Senator Dietrich. I'm chair of the Joint Committee on Special Claims in the state legislature. The committee is here to hear your claim for personal injury for $1,500. So you're on speakerphone with the committee. So we've been given all of the documentation for your claim. We're going to look at that. You're going to be asked to give us any additional information you'd like to in just a minute. When you're finished, then the attorney for the Department of Corrections will also give the department's position. Then we may ask some questions, and when that's completed, the committee's going to take a few minutes and determine our decision on your claim, and we will get back to you within 21 days on what that decision is. Do you understand?
Yeah, yes, ma'am.
Okay, so Mr. Thomas, would you like to explain to us what your claim is about?
I slipped and fell in the shower on October the 2nd. I was in belly restraint, so I didn't have full range of motion of my hand any way to try to prevent from falling. I received a deep cut down to my elbow bone. They said nothing was broken, and I was sent to the hospital, and they used some tape instead of stitches. I also have as a witness Dr. Garza here. When he looked at my elbow, he was upset at the fact that the hospital and the community did not stitch my elbow up. It took almost a month for it to scab over because it was infected and it was inflamed. And right now I have disfigurement. It's like a permanent bruise on my elbow. My argument is if you look at Exhibit J and the pictures that the state used, it's very misleading, ma'am, because the floor is not rugged. It's not a gridded floor. The material, the aggregated and quartz concrete that they use would make you believe that this floor looks like sandpaper, and it's not. It is a smooth floor. That's Exhibit J, the close-up picture that they show of the floor. Then they have a picture for I don't know what reason, of the handicap shower. That's a shower that we're not even allowed to use, and it doesn't even have a water nozzle to be able to use it. And then they have another picture of a shower that's not being used. What they fail to do, ma'am, is if you look at the picture with the yellow strip on the floor, and you will see that it's some water, a puddle of water on the floor. That comes from shower number 1 in the shower that I was in, that the investigator and these people here deliberately left out so you couldn't see that water comes out that shower on the floor. Soapy water comes out of that shower all the time, and it goes over by the sink, which is next. But they don't want to show you that picture. This picture with this chair, ma'am, that's in there, the handicap chair, that chair was not in there at the time when I fell. In the pictures of the floor where I fell, where it was accumulation of blood, and they had to use towels to clean the floor or put on the floor. If you also look at the floor, ma'am, when I say that, to define negligent is defined when a person or a facility or a company fails to take reasonable care and caution, ma'am. I've always asked them since then, why did they not have rubber floor mats or even floor strip grits that we can walk on in these showers? Because that could have reduced the risk of serious harm in the shower. And the state is up here, when I mentioned that in my claim, he responds back like they doesn't need it. He's trying to make a scientific, trying to tell you that this floor is slip resistant, and it's not, ma'am. The floor is smooth. You can take a cotton mop and mop the floor. These are blatant lies that he's telling you all because you all are not here to be able to touch this floor. But there's security staff in here. There's other staff in here, MHPD staff in here that can attest and verify to you that these floors are slippery. Because it's the same floor that's in my room, ma'am. And I mop my room every other day. And he says that this concrete is slip resistant, and it's not, ma'am. My injury went all the way down to my bone. That's why I also say that the state is negligent. I have to show and establish where they're negligent. And the shower itself, in those pictures that you got, tells the whole story. There's no wet floor signs. There's no precautionary signs in there, nothing to prevent or help reduce the risk of anybody, not just me, of falling, ma'am.
Thank you, Mr. Thomas. Committee, do you have any questions of Mr. Thomas? If not, we will hear from Joseph Bezzati from the Kansas Department of Aging and Disabilities, not Department of Corrections. That was my error if I said that earlier. Are you on the WebEx with us?
Yes, I am.
Mr. Bezzati, would you like to give the KDAD's response to this?
Yes, ma'am.
Welcome.
Ma'am, And may it please the committee, my name is Joe Bizzatti. I'm an attorney and a fairly new attorney at KDADS. Just so go easy on me, but I think I have prepared before the Joint Claims Committee and other matters with other state agencies. But I want to give a little bit of background about what the Larned State Hospital's investigation revealed to me and to this committee following this incident. So what was told to me was that yes, on October 2nd, 2021, Mr. Thomas at about 5:35 p.m. slipped and fell in the shower. He did sustain a laceration to his right elbow. That laceration was observed to be 1.75 centimeters directly over his right elbow. He was sent to the emergency room approximately an hour later after the fall, had to get some paperwork together to do the transport. And he went to the Pawnee Valley Community Hospital emergency room. Mr. Thomas has provided evidence in a radiology report dated the same day of the fall that there was no right elbow fracture. There was no excess fluid in or around the joint, and the soft tissues were normal. There was also medical documentation that Mr. Thomas did not sustain a broken bone at all, and the medical professionals provided care in basically putting steri strips over the wound, determining that sutures or stitches weren't necessary. So that's kind of the background information, but I do want to provide a little bit better explanation about what negligence is and what's required to prove negligence. It's a duty, a breach of that duty, causation, meaning a breach of the duty caused the incident, and then to establish damages. All those have to be proven by Mr. Thomas to show negligence. Mr. Thomas alleges in his complaint that KDADS has a rule that requires residents who are in partial restraints to shower with him. Technically speaking, that's not true. We have a policy, and I provided that policy in one of the attachments. It's the Individual Person Management Plan, IPMP. And that policy speaks specifically to what was going on this day when Mr. Thomas unfortunately fell. Mr. Thomas was on an IPMP, and that is a process that utilizes that is utilized to maintain a safe and secure environment when a patient poses a security or a management risk on the SPTP program that can't be addressed with routine psychiatric methods. The IPMP policy allows for additional security measures. In the case of Mr. Thomas, he had a belly chain with handcuffs, and the handcuffs were basically chained to the belly chain. So he was technically in partial restraints, and he was in partial restraints because he was placed on a PIMP policy where he had special precautions due to violence and security risks. So it wasn't required that he have partial restraints for showering. There is no rule for that. But the IPMP policy and the restraint policy doesn't prohibit showering with partial restraints either. And it definitely doesn't require removal of partial restraints for purposes of showering. So what I'm getting at, Madam Chair, is that Mr. Thomas has failed to point to a duty that KDADS owed to him to remove the partial restraints for purposes of showering. He hasn't established that KDADS violated any of its own policies or practices. And ultimately, without a duty requiring KDADS to remove the partial restraints, Mr. Thomas, his claim should be denied, and KDADS should not be found negligent because no duty exists under his first allegation. His second allegation, and he mentioned, was that KDADS didn't have any signs, handrails, nor any floor grip strips. But to provide some context, I contacted John Golightly, who's KDAD's project manager. Back in August of 2016, KDAD's had the showers and the shower floors resurfaced. That resurfacing included, as Mr. Thomas accurately stated, a quartz aggregate flooring. And that was completed in 2017. There was an inspection done after the installation of that resurfacing, and it was determined then that a cottonhead mop, if you drug it across the floor, would snag. So there had to be a balance struck between sufficient slip resistance and also excessive abrasiveness. This was so abrasive that they couldn't use regular traditional means to clean it and had to find other methods to do so. So that was back in 2016 and 2017. Let's fast forward to October 27, 2021. Brian Stahlacker, who's an environmental safety officer, went out to the showers. He conducted his own inspection, and he reported back to me that he used the cotton mop and it still snagged the grit on the floor. He also wetted the floor, stood on it, and determined that the grit floor would not allow his feet to slide. So in summary, in 2017, KDADS took adequate measures to resurface the flooring. An inspection in October of 2021 determined that the floor surface maintained sufficient slip resistance. Mr. Thomas has not shown that KDADS owed the duty to install signs, handrails, or grip strips. He's not pointed to any law. He's not reported to any policy that those things be installed. Mr. Thomas has also not shown that KDADS committed an act or omission that caused this accident, this fall. So without proving that KDADS committed a negligent act or omission, or that KDADS had a duty to install signs, handrails, and grip strips, KDADS should not be found negligent. And I've got one last point. Mr. Thomas has not provided the Joint Committee or KDADS any evidence whatsoever establishing the amount of damages he claims he sustained or any monetary loss attributable to the incident. Even if KDADS were to be found negligent, which we weren't, Mr. Thomas hasn't shown how he arrived at the $1,500 amount. So under a negligence action, you have to establish damages, and he's not done that. So KDADS would respectfully request that his claim be denied. And one last piece, I don't see or I don't know of any indication that Mr. Thomas has exhausted his judicial remedies or administrative remedies in this case. So in the alternative, under Rule 2, the claim could be dismissed.
Thank you, Mr. Bizzotti. Does anybody on the committee have any questions? Senator Haley.
Thank you. Thank you, Madam Chair, and thank you, Mr. Bizzotti, for your review. I'm curious, I know you say you've just been there recently. Are you familiar if there have been any other claims for those restrained? Is this the first in your limited knowledge, because you've just been there? I don't recall anywhere near this set of circumstances, certainly haven't been brought to this level or frankly in other areas where it's been. Have you heard of this before? Or have you seen an allegation of a slip and fall restrained otherwise?
No, sir, I have not. And in my investigation, I inquired whether this was something that happened frequently. And without divulging any HIPAA, not naming names, we have a fall unit or a group that deal with falls. And a fall like this hasn't occurred to my knowledge previously.
I don't understand that, and that don't make sense just because I don't understand that. And for him to be having the right to sit up here and speak on somebody else, whether they sell or not, you still can't say that their floor is slip resistant. And you telling me that just because somebody else didn't want to file no injury claim, because it has been people that have slipped in this shower before over there in South 2, in which I resided in.
Thank you, Mr.
And just because somebody didn't file no injury claim on theirs doesn't mean it doesn't exist. It doesn't mean it didn't happen.
Thank you, Mr. Thomas. We appreciate your information.
I'm sorry, ma'am, because ma'am, I'm sorry for interrupting, but I feel I should have an opportunity to rebuttal because, it doesn't, the state can't sit there and say because they don't have no floor strips, they're not obligated to put some type of warning or precautionary sign in a shower room that everybody knows that gets wet with floor and different soaps and conditioners or whatnot. They can't say that it's not their responsibility to forewarn or put precautionary measures in the shower to help reduce the risk falling and even hurting himself severely. Ma'am, Dr. Garza is my witness about what my elbow looked like when he observed it the next day and what he said should have been done at that hospital, ma'am. He's trying to diminish my injury, ma'am. He's seen bone, ma'am. Dr. Garza is the doctor here. He had to use some liquid glue, ma'am, some type of liquid glue stitch stuff to try to close my wound so he can heal, ma'am.
Thank you.
And he worked it.
Thank you. We appreciate your additional information, and we can hear the angst in your voice. So thank you so much. Committee, do you have any other questions or comments? Oh, I'm sorry, Senator Haley, I'm sorry, didn't look up.
Thank you. And for Mr. Thomas, then, there was a question. This is Senator Haley again. The request was, in fact, it was brought up in testimony. Why $1,500? How was that reached? I don't know if you can hear me or not, Mr. Thomas. How did you reach that amount for your claim of $1,500 for compensation for your injury?
Because, sir, they were negligent. I sustained injuries behind it. I also have deformity in my left elbow because it's a bruise that is not, well, he called it a stress. He called it some medical term the doctor called it where I got disfigurement on my elbow. That's permanent, sir. That's permanent. That's damages enough, and the law doesn't state that I have to show significant injury. I have to show and establish that it was what caused the injury. And if I was out there on the street, it would have been medical bills for just going to get X-ray and whatnot. And the people and they say this, but I'm a ward of this facility, and they have medical records, and it does cost. And I'm saying that they're negligent, and that's why I came up with the amount. Now, I ain't said that that's the amount that I deserve. I ain't saying that's the amount that I deserve, but I am saying that I feel I should be awarded something for the damages that incurred by their negligence. And to sit up there and say they're not obligated to have shower signs, wet floor signs, you might as well not have no wet floor signs in this facility, period. You must not have no signs, period. That's a carelessness. That's carelessness in itself.
Thank you, Mr.
Because you can't tell me that a shower room shouldn't have no precautionary measures to prevent. He cannot say 100% proof that no one can slip in that shower. And I wish you all were here to see this floor that they're talking about. It is smooth, ma'am. It's not rigid. You can take a cotton mop and mop it.
Mr. Thomas, thank you. You answered the question. Appreciate that very much. Thank you. So at this point in time, if the committee doesn't have any other questions or comments, we will end this portion of the claim discussion. Thank you, Mr. Thomas. Appreciate your input today.
Thank you.
Thank you. Committee, those are all of our claims for today, so we need to go back and vote, and I apologize, I hadn't marked all of these. We have 7198, which is Mr. Garcia, claim 7192, Mr. Payton, and we have claim 7207, Mr. Thomas. We've already dealt with 7201. Is that correct, Merle?
That is correct, ma'am, but someone may correct me if I'm wrong. I believe we still need a motion to approve the motor fuel tax refund claims.
Thank you very much. Thank you for that. Yes. And the motor fuel tax refund amount was $29,457.39. I thought we did that. To pay from existing funds, didn't we not? We didn't actually make the motion. Okay, very good. Thank you so much. Well, shall we start with the motor fuel tax refund? That way we know we've got that, and then we'll go back to the regular claims. I would take a motion on paying the motor fuel tax refunds.
Madam Chair, move approval of the motor vehicle tax refund claims from existing funds in the amount of help.
$29,457.39.
So moved.
Second, Senator Straub. Any discussion? All those in favor, please signify by saying aye. Any opposed? Okay, motion carried. And now we'll move on to the claims. The first, there are three of them. The first claim is 7198. Mr. Garcia. Motion?
Madam Chair, I moved in denial of claim number 7198.
Is there a second? Representative Samsel. Is there any discussion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Motion carries. Claim denied. Next, we have claim number 7192. This is Mr. Payton. This is a personal injury claim.
Madam Chair, I move dismissal of claim number 7192 pursuant to Rule 2 without prejudice.
Is there a second? Second, Senator Haley. Is there any discussion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Thank you. Claim denied for Rule 2. The last claim was 7207. Mr. Thomas, do I have a motion?
Madam Chair, I'm going to make the same motion. I'm tempted to just move denial because of the lack of the damages set forth there, but I think for consistency's sake related to personal injury type claims, I'm going to move the dismissal of claim number 7207 pursuant to Rule 2 without prejudice.
Thank you. Is there a second? Senator Straub, any discussion? All those in favor, please signify by saying aye. Aye. Any opposed? Okay. Motion passes. We're going to dismiss claim number 7207 per Rule 2 without prejudice. Senator Straub, you have a question?
Thank you, Madam Chair. Unrelated, I apologize. Earlier, I got the two statutes mixed up, and I think you were trying to tell me that. Somebody just needed to say it a little bit more bluntly. So if we could ask the staff to disregard that in the comments to one neck. Thank you.
You're welcome. Thank you so much. Any other comments or questions on any of our claims? So our next meeting will be on December 16th, 9 a.m., and it will likely last until 4:30. We have a lot to get done. That's our last meeting. Merle, did you say there's a significant number of claims?
Yes, ma'am. I would estimate that there's probably about 30 to 32 claims to review, which this committee has done. I think in our first meeting we did an equivalent amount, but that is a heavy load. So that is usually a full day of 9 o'clock till about 4:30 in the afternoon.
And yeah, so we'll ask you to please let us know if you can attend in person. We'd appreciate it. We need 4 for a quorum. Representative Miller.
How much do we get per claim?
Standard daily rate here. So thank you all so much. I appreciate you being here today. I will adjourn the committee meeting now at 2:40. Merle, did you have something before I adjourn?
Sorry, ma'am. Just a reminder, if you have the electronic version, electronic file on your computer, if you could delete those, please. And I think, Connie, if there's any travel vouchers yet, just a reminder to submit those to
We have them all. I think so. Very good. Committee adjourned. Thank you so much.